Case diary is not available, my lord.
Case diary is not yet received. In 21, case diary was available. Oh, that is written. 15 is not received. Case diary is not received. Issue reminder. Interim. Interim stands extended till the next date of listing. When do you want it? Thursday. Next.
Next, 18, 19,
17.
17. Oblige, your lord.
Well, item number 11, my lord. CD is available, but I have some difficulty.
You
right
have some
now.
difficult.
Some next week, any date, my lord.
No.
There is interim order, my lord.
Case diary is received and shall be retained. And however, the matter is adjourned on due to some personal difficulty of the petitioner counsel. List the matter on. You can suggest a date as per your convenience. List next week on Wednesday. Wednesday, did you? Wednesday?
Oblige.
Wednesday. Interim stand extended till the next date of listing.
Oblige.
May it please, your lordship. Lordship, I beg to mention item number 18, lordship. Lordship, I have instruction to issue this well, please.
Your good name? Kanu. Yes. Learned A.K. Kanu, Learned Counsel. Submits that he has instructions to withdraw this matter.
18.
Prayer is allowed. The bail is disposed of upon withdrawal. Charge sheet submitted to me. It is submitted by Learned Prosecution accordingly. That charge sheet has also been submitted in the meantime.
Thank you, Lordship. Item number 19. That's why here we need to bring in certain facts. So that we need to find an additional. So, Lordship, this matter can you take after the vacation, Lordship? Interim is there.
We have received the case and send back the case date. After vacation.
After vacation.
After vacation.
After vacation, then we have to send back the case.
Can you, since it's an AB with interim, can you file it? I mean, can we take it up before the last date over last week or something?
No, on the last week, Lordship.
First day of, don't keep it towards the end, Monday.
Monday,
That will be, Monday will be, I think,
14th.
no, 15 or 16.
15 or 16, Lordship.
Huh? 16.
16.
As prayed for, the petitioner side shall may file an additional affidavit. Full stop. The case diary received may be retained. Interim bail stands extended in the next date of listing. This is the matter on 16/12.
I please your lordship. Lordship, I beg to mention item number 23.
Yes.
Your lordship, we have taken Dasti service in this case and we are yet to file an affidavit. So we want a week's time for
Okay,
this.
no problem.
Interim order shall continue.
Yes.
Lordship.
The learned counsel for the petitioner, 6 D. Sharma, you are?
No, A. Tiwari. I am
A.
appearing on behalf of A.
Learned counsel, 6 weeks time to file compliance affidavit with regard to Dasti service. Prayer is allowed. Interim order stands extended till the next date of listing. You want me to fix a date?
Any date. can-
List the matter next week on a date to be fixed by the registry.
Obliged.
Okay, come.
May I please your lordship? Lordship, I beg to mention item 25 of orders. Lordship, my senior is suffering from stroke and currently recovering. Lordship,
Oh, no, it's okay. I'll, Mr. Sinha,
P. Sharma, Lordship.
please.
Sir, I'm appearing on behalf of,
Okay, he's not well.
yes, Lordship.
He's in hospital.
Uh,
No, I'm giving you the adjournment. I'm just asking out of concern.
Sir, feeling better now,
Uh,
but recovering.
The leading counsel is stated to be unwell and quite unwell. And therefore, on the prayer of the learned junior counsel, the matter is adjourned. Any interim order? No interim order is there. No? This is should we fix it after vacation?
Yes,
This is the matter.
any day.
Yes, this is the matter in the month of January on a date to be fixed by the registry. If it gets delayed, you make a mention. Okay. No problem.
Deeply obliged.
May it please your lordship? Lordship, I beg to mention item number 16.
Yeah.
Lordship, CDR is not available.
CD is not
Not
available.
available. Yeah. And interim order shall continue.
CD is not available.
It is not available. So I have made a prayer for another date.
Now, so shall we fix it after vacation?
Interim was there.
Yes. Case diary is not received. Issue reminder for the same. List the matter in the first week of January. on a date to be fixed by the registry. Interim order stands, or should we fix it before vacation? Since the interim order is there, 16. huh?
Last week with the motion, they lost, motion will be there.
True, mostly motion. So let it be then after vacation. In the first week of January, date to be fixed by the registry. Interim order shall stand extended till next date of listing.
Highly obliged.
Should we take up the bails first? Because though I mentioned 10:30, but it's not listed, his matter. It's come, no? His matter has come.
What if it's in the supplementary?
Listed. The time is not mentioned. We can go through the bails. It's on, many of them are already mentioned. So I think that will be better, I think. Just hold back for a minute. We'll finish the bails because mostly they are AB, so it won't take much time.
May I please, Your Lordship?
Yeah.
Lordship, regarding item number 27 of the supplementary list,
Mhm.
we have filed an additional affidavit. Lordship may call for it to be tagged along with the records.
Oh,
And Lordship, we have also received the information that the red TCR record is also available.
available.
Lordship may call for that as well.
The item 27, the learned counsel, you are Mr. Sultana
I'm and Sultana.
and Sultana, learned counsel.
Lordship, I'm not seeking for an adjournment, Lordship.
Ah.
I'll just provide the requisition for.
Oh, it's a requisition, then it's, no problem.
Yes.
Wait, please, my lords. Lord, item 22, I have been informed that the CD has not come.
Okay. Yes, no problem.
Perhaps the matter could be fixed on the 13th then.
Okay. Case diary is not received, issue reminder. List the matter, and when do you want it? Suggest me a date. You can suggest
13th, my lord.
13th,
13th.
13, 12. Any interim orders there? 13,
13th. I'm so obliged.
13, 12.
Yes, my lord.
Saturday.
Oh, sorry, that's a Saturday. You can, earliest working date is 12, 12, 12.
I'm so obliged, my lords.
Bail hearing BA, item number 6.
6. Okay.
Fair visual option.
This one. And this here. Charge sheeted matter, no? Charge sheeted matter.
Kashita
Kash-
matter, my lord,
Is,
the TCR was called for.
oh, I see.
So
Hmm.
My learned friend is, probably he has.
My lord, I've not been able to go to the scan copy of the record, my lord, but subject to my lord, my senior friend's convenience, my lord. May I pay, my lord, some next week, my lord, any day?
You wish. Today is Friday, yeah, Friday, no? Next week, yeah, fix it as per your convenience. Those scan TCR has been received, but the learned additional PP, Mr. RJ Buru, seek some time to go through it.
On 15th, my.
No problem.
On 15, my lord.
This is the matter on 15/12.
Deeply obliged.
Problem.
Item number 7.
Service report was awaited.
My lord,
Any instructions?
Stephen, we have not received, my lord.
So can we, you can take instructions?
My lord,
They have not appeared also, but I think 28/5 is in custody.
This is the, my
Well,
lord.
as prosecution was directed to take instructions, but it has not come.
Not come, man.
The
18 December, man.
Scan record is available, but instructions regarding service upon informant not yet received by the prosecution. The prosecution shall take instructions regarding such service. This is the matter on
18, man.
18th.
18, 12.
Today is If possible, keep it next week,
Then
if possible.
12, my lord.
12?
12.
4. Okay, 12. We'll dispose it of 12. No, I think what you do is fix it on 11. So if notice is complete, we can appoint an amicus and next day we can take it up. 11, huh? 11. Huh?
Number 8.
Wildlife.
8, my lord, wildlife council is appearing, my lord.
B. Sharma, yes. We'll wait for him. Council, if petitioner is also needed.
Item number 27.
Kindly pass over the matter to the library.
Son, affidavit was called for.
Item number 9.
9, my lord, may I please, your lordship? Submitted, my lord, 9.
Charshir Summit.
25th March is the first appearance date. Lordship may protect till that or absolute bail may be.
Let the scan copy be called from, my lord. In this case, my lord, Charshir submitted in the month of April 2025, my lord. So till now, my lord, my trial must have been proceeded, my lord. So may I pray, my
I'm just seeing what are the sections. If the detention is not necessary, they can appear.
Yes.
And scooter,
Lordship, I have a
quarrel
copy of-
regarding relating to parking of a scooter in front of a shop. Let them know. No need to have. লিখা আছে আগৰ 9/4/2025 order, the first two paragraph 1 and 3. Listed. The petitioner was granted interim pre-arrest bail by order dated 9/4/2025. RJ Bura, learned additional PP submits that in the meantime, the case has been charge sheeted already. The petition, you have submitted, right, this one? The petitioner side has submitted before the court certified copies of the charge sheet, certified copy of the charge sheet. In the context of the aforesaid developments, the interim bail granted to the petitioner by order dated so and so is hereby made absolute, subject to the condition that this shall be available for the trial if one commences and shall not hamper or tamper with evidence. Bail petition stands allowed and disposed of. You take this, sir.
Obliged.
10. Item number 10.
FSL.
Well, item number 10, my lord, they have received the case diary, my lord.
Mhm.
But the FSL report is not received, my lord.
Mhm.
So I have said, my lord, they have entered from the, my lord, DFSL kindly para, my lord, but the report is not ready, my lord.
What section is there? He's on interim bail.
No, he is not interim, my lord.
He's on interim. He's on
He is
interim.
interim. It's a case of murder, my lord, 103.
Granted by coordinate bench. So, no problem. The FSL, you'll need the FSL.
My
Right?
lord, yes.
Case diary, what will you do? Retain
No,
it?
no, we'll return the, my lord, return the case diary, my lord.
Return the case diary.
Lord, may fix it, my lord, after vacation, my lord. So that, my lord, I will get some time to collect the FSL.
In the meantime, your lordship may continue the.
Yes, don't worry. The FSL report as called for is not yet received. Stop. The interim bail granted to the petitioner by order dated 9/4/9/25 stands extended till the next date of listing. The case diary may be returned back and procured again with up-to-date investigation, including the FSL report if available. Stop. List the matter. You can suggest a date in the first week of January.
No, 8th of January, my lord.
8/1/2026. 8/1/2026.
Item number 11.
Mention. It is mentioned.
11, my lord, case diary not received.
Intervention following seventeen. I think it was mentioned. 11 was mentioned actually. Did, oh, wait, now I, Wednesday.
It fixed source. 10, 12.
Item number 12,
May I please, your lordship? Lordship, item may be passed over for the time being.
After some time.
Yes, lordship. Bless you.
13,
Lordship, the matter may be taken up after some time, your lordship. Senior counsel elects in other outlines.
14,
Anticipated bail
Yes, sir.
application, madam. All the prisoners, they are, madam, on interim bail.
Mhm.
So number 1 and 2, they are the, madam, father-in-law and mother-in-law. They did about 75 years and 70 years. Petition number 3 is also, madam, the eldest brother-in-law.
Mhm.
They did about 54
Oh,
years.
mhm.
Though initially, madam, the case was registered, madam, under section 1091, but
Hmm.
subsequently, madam, section 108, madam, has been added
Hmm.
on 24/7/2025.
Mhm.
And your lordship may kindly see the forwarding report of the husband who was arrested, madam, on 25/7.
He's on bail, husband.
Husband, he was madam,
Arrested.
arrested thereafter he is
He-
released on
he
bail.
bail.
His forwarding report is at page 42.
Yes.
Madam, you see, madam, serial number 2, during the course of investigation, arrested person admitted his guilt. During the course of it learned that the accused person is staying away from the victim and did not support her to run the family and facing financial problems since long time, due to which he often pressurized his wife. During the commencement of the crime, arrested person was on video call through Instagram app with the victim and both were on verbal fight. Due to his instigation, his wife Sunita Shah committed suicide. After commencement of suicide, he informed neighbor for help lately. Direct allegation of 108 against the husband. Initially, though when the case was registered under the different section, the FIR lordship will find at page 24. And that person is also released on bail.
Yes. Here in this petition, who are there? 3 people.
3 people,
All are on interim now.
all are interim.
Madam, in this case, my lord, we received the case diary, my lord, but it was sent for up to date, my lord.
Up to date.
Now, up to date case diary is not received, my lord.
Dilip Agrohari Bonia is, he's, who is he? Uncle.
Father-in-law and mother-in-law of the victim.
Yes.
It is
and-
number 1 and 2. And the 3 is the eldest brother-in-law. The victim husband was the youngest one.
Okay. Get the case there for another date with fix, extending the interim. But it should be disposed of. It's been there for a long time, I think, huh? We'll dispose it of for PJ Sarkya, learned counsel advocate for the petitioner. The case diary is stated to be not yet received, full stop. Issue fresh requisition. The interim bail granted to the petitioners
On 2 different dates.
on 2 different dates.
On
Right order dated so and so. and
15/9/25.
And 26/9/25 stands extended till the next date of listing. The other earlier date is,
15/9/25.
when should we fix it? After vacation? Or,
On 19 or 20, my lord.
Let me
January.
after vacation. It's
After vacation, 19, 20 January.
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 I thought that December. Always.
20 January, my lord.
is it okay? PSEC.
20 January.
Any difficulty? No.
17,
It's a Tuesday. Let it be on 21st, Wednesday,
21st.
So 21st, right? Not 21st.
17,
17 case diary not received, my lord. Yeah.
It's appeared. So
That's it, my lord. Interim, huh?
case diary is not yet received. Issue reminder. List the matter on
My lord, 18, my lord, is this one.
this month 18. Don't keep it on the last day, just little before, 18/1, 18, sorry, 18/12, 18/12. Bail hearing.
2020, 20.
Diary has come, 28, item 20, item 20, diary has come. Let them appear then, we'll wait for them. We take you to hold, just option. Yes. We have. So, it would have ঠিক আছে এটা কি সরলাম এটা বেল এটা হবে না hearing plus এক মিনিট just the orders দুটা আছে এটা মেনশন লিস্ট হয়ে যাবে no problem. You can take the mission matter to me.
মারা তো ব্রেক নেবে তার সাথে
Break no 1 second there. The same time bomb as it. Okay, let's see. So time being one more round.
Time being at 8, 27.
Oh, not ready after some time.
After some time.
No, it's okay, no problem. You let me know when it comes. When you're ready, we'll take it.
That's it.
My lord, back with me. Well, I'm sorry, my lord, I think 7, my lord.
No, no problem.
Uh,
We've kept it timing. We've kept it. Huh?
Item 12, time being 12,
Item, just a minute. 7,
12,
7 cube.
7 to the better category.
Hey,
What is it?
I have given an, what is the order we have given? I think, service is not complete.
my lord, on
I have
the
asked them to take instructions, fixing it next week, I think.
Next week.
Just take the dates. Just,
Item 7, no?
just a minute.
my lord, today, my lord, they were supposed to, my lord,
Yes, they were supposed to take instructions, but they have not taken. He's in custody since May or something.
my lord.
Which date was fixed? Sibu? 11, 12. That's all right. No, I have given it like that.
I have let you.
Item number 12, timing.
May I please, Your Lordship? In regards
You're
to,
ready?
in regards to item number 12, Lordship, is the pre-arrest bail application. The petitioner was on interim bail, Lordship. After that, the statements were recorded. Lordship. Case diary did came, but up to date case diary was called for thereafter. Lordship will find the FIR, which is on page 22, Lordship. Okay, basically, it is a civil dispute, Lordship. If I may read out the FIR, Lordship.
Yeah.
With due respect and humble submission, I have the honor to inform, Lordship has got it, Lordship.
Yes, I am on that.
Inform you that I am the owner of 2 numbers of water browser cum oil tanker bearing registration number so and so and so and so. Both the vehicles were given on rent to Mohammed Rafiqul Haq, a contractor residing at Bahata Sarili in the year 2022 under 2 separate agreements. The dues for the vehicle bearing registration number so and so has been fully paid by Rafiq Haq, and the vehicle was returned to my custody without any dispute. But the problem has arisen regarding the second vehicle bearing registration number so and so. On dated so and so, the driver of the contractor Rafiqul Haq came to my garage and handed over the vehicle key, claiming that all dealings had been settled through my cousin brother Mohammed Samim Mansuri, alias Munna of Rangapara, as Mohammed Samim Mansuri was involved in dealing with the hired party from the beginning. I accepted the vehicle in good faith. Subsequently, I came to know that Mohammed Rafiqul Haq did not settle any outstanding dues with Mohammed Samim Mansuri. Besides, he fraudulently handed over the vehicle without clearing the pending rent of rupees 4,80,000, which remains unpaid to this date. Furthermore, the returned vehicle was found to be in damaged condition. This is in direct violation of the terms of our agreement, which clearly state that any damage occurring during the hired period would be repaired at the cost of the hired party. Hence, Rafiqul Haq, along with his accomplice Minarul Haq, has committed criminal breach of trust and sitting, causing me substantial financial loss. I have repeatedly visited their residence at Bahiyata Sarili over 1 year, but they have only given false assurance regarding payment and repair of the damaged part of the vehicle, so I have not taken any action whatsoever. But the accused party neither paid my dues nor repair my vehicle. Besides, they threatened me that I can't do anything to them. I therefore pray before your good office to kindly register a case against so and so under the
Okay.
relevant provision of law. Now, Lordship, regarding in the FIR itself, it is stated by the complainant that all the financial dealings was dealt by the complainant
Cousin brother.
cousin brother. Now, Lordship, we have also furnished all the documents regarding our bank statement. Lordship will find that from page 25 to page 84, Lordship. Lordship, in that regard,
Just a minute, there is come. Prima facie, I mean, it is arisen out of, it may have a criminal dimension, that's another matter. But it has arisen out of a transaction.
My lord, but the question is that, my lord, they have not cooperated the investigating officer properly, my lord. They have just prepared, my lord, but they have not cooperated in investigation. Secondly, my lord, as per the note of the investigating officer, my lord, sufficient material has been collected against them, my lord, and investigation is almost complete, my lord. That I will say,
He has not appeared,
no, he has appeared, my lord, but he has not cooperated, my lord.
otherwise not cooperated.
Not cooperated, my lord. He has not given any statement of the, my lord, the transaction amount, my lord, how it was.
But his statement has been recorded.
Statement has been recorded, but he has
But-
not cooperated. But this
But
is the,
but
my
the
lord,
statement
this
is,
is the objection by the IO, my lord.
objections of the IO. Anyway,
Lordship, in that regard, Lordship, not only we have provided the bank statement, but we have went to the investigating officers thrice. Lordship, regarding that, we also have a Indian Post, we send it through the Indian Post, Lordship. We also have the ticket. If Lordship allows, then we can file additional affidavit. We have sent it to the investigating agency, directly to the investigating agency. We have also given them a soft copy. They refuse to give a signature that they have received. So we have also posted through the
why
all
they
the
refuse?
relevant bank documents. Lordship.
They should take it anyway.
Lordship, in that regard, Lordship, the agreement was executed on 2020, on 2022, on March, and it was handed over on 31/4/2024. Lordship, until then, if 50,000 is the amount which was fixed as per agreement, it has to be 12,50,000. And as per our bank record, we have already paid 11,67,600 rupees. And we have annexed the.
I think that may not be a bad idea. That, one option is this, that we can ask him to record his statement again, appear for. Recording is not in the person's hands, is in the hands of the IO. He can only make himself available, that's all. If that statement is incomplete or something, we can do that. We can extend the interim in the same process and give them an opportunity to file an additional affidavit if you want to bring those documents.
Yes,
Can bring it.
Otherwise, investigation is also completed. Question is that investigation, if there is a criminal dimension, investigation can continue in that, but whether his custodial examination may be necessary at this, considering the nature of the
Only
dispute.
my
I can do that.
submission is that, my lord, honorable court, my lord, grants interim protection to an accused, my lord, in order to, my lord, to cooperate with the investigation. My
That
lord.
is also
Cooperate with
condition.
the investigation does not mean that, my lord, he does merely appear
Let me
before the
have a
IO,
look.
my lord.
Let me
Yes.
have a look.
It could just-
You can file if you see, if that is what you, as per your contention, you paid almost the entire amount. Then that is a very important fact in your favor.
That
So
is-
you bring it on record by an
That is there in
affidavit.
the record. If Lordship wants, then we can.
No, not my question of wanting. I mean, if you think that will help your case, and then because since you are on interim,
Yeah.
so that can always be extended for some more time.
My bank
And you
statement
file
already-
it, in the meantime, you file it.
My bank statement is already there in the record, but the question is whether I have given the bank statement to the investigating officer or not. That was the question raised by the learned prosecution side. But I have went to the investigating agency, I have provided them with the bank statement, but they have not signed that they have received. So what the petitioner did, that they also posted the same, Lordship, and that has been duly received by the investigating agency, Lordship.
Anyway, I think it's okay. I think we can fix it. Can we fix it in the first week of January?
That will be second week of January.
Then second
we
week
have
of
to
January.
submit that
In the
in
meantime, you file an affidavit. But you can, since the investigation may be completed by then, you can appear again. And then you have a order of interim bail, you render full cooperation.
Your custodial interrogation is not required, Lordship, then actually we granted, Lordship. We
No,
face the
that-
trial, Lordship. These are
Since it is, anyway, it is not such a.
agreement
big
is there
matter also.
already, Lordship. And we will appear
Then
for the
let
trial.
it, you bring the addition, file the additional affidavit. That will be a matter of record and that will be good for you maybe. For trial stage also, it may be good for you. If it goes to that stage, anyway. So the case diary is received. The learned petitioner counsel submits that matter is largely a civil dispute and even with regard to that, bulk of the pending amount has already been cleared and stuff. And in this context, they may like to file an additional affidavit if directed. On the other hand, the learned additional PP submits that though the statement of the petitioner has been recorded pursuant to grant of interim, but the IO has projected that his cooperation has not been forthcoming. Otherwise, full stop.
And sufficient material has been collected.
And there are also incriminating materials against him. Nevertheless, the petitioner side is given a liberty to bring additional facts on record through an affidavit. The interim bail is extended till the next date of listing. However, the petitioner is directed to render full cooperation to the investigation, and he shall once again appear before the IO, making himself available for examination. And if the IO thinks fit, his statement can be recorded once again. The case diary shall be returned and to be procured again for the next day. List the matter on.
On my lord, 21/2, my lord, 21/1, my lord.
Give it
Okay.
before Bihu.
No, before we were only 5 days, my lord.
Hmm.
Only 5 days, my lord.
We will
Cannot
file
count.
additional affidavit in regards that bank statement is already there in the court's record. Lordship, we will file additional affidavit in regards that only.
No, I am not saying with regard to what you file, whatever you want to file, you file.
But-
Flexible.
21/1, my lord, 2026.
21/1. List on 21/1/2026.
Deeply obliged.
Thirteen time being. 13 time being.
Is it ready? No, not ready. That's all. No problem.
Ready.
No, not ready.
20 time being.
2 zeros.
Well,
You're-
please, your lordship.
You're ready?
Lordship. Lordship, in this case, my lord, the informant lost the FIR, alleging that they were carrying some Erica nuts, my lord, by a truck, my lord. And the two vehicles, may I read the FIR, my lord? That is at page 10, annexure B, my lord.
Yes, I'm on 10. You can read.
Lordship. With reference to the subject cited above, I do hereby honor to inform you that on 23/7/2025, at about 6 p.m., while I along with my driver friend Amjad Hussain Laskar were coming from Kachar towards Guwahati in my truck bearing number so-and-so, loaded with Erica nuts. Two vehicles, one is an Alto bearing registration number so-and-so, another a Tata Yodha bearing registration number so-and-so, wrongfully restrained our truck somewhere between Lanka to Bhalukmari on the highway. Then from the both vehicle, two persons came to us and entered our truck by identifying themselves as police. I have noticed more 5-6 persons in both the vehicles. At first, they took our truck towards a Bharat petroleum pump nearby the overbridge of Bhalukmari. After that, the persons along with both the above mentioned vehicle took my truck towards Kaki Tongia area and entered into rice mill. After some time, the owner of the rice mill came to the place and started arguing with the persons I heard that the owner of the rice mill threatened them of police and asking them why they have carried the truck with areca nuts to his mill. He also asked them where is the actual truck he hired. The persons took us to the rice mill with an intention of dacoity. In that moment, I came to know that the rice mill owner is not among those culprits. Then I shouted loudly and asked for help. At, at the at the meantime, the culprits fled away from the place and the owner of rice mill rescued us.
Mhm.
After that, we rested there for a night. I identified the culprit. My lord, the
Two
alleged
persons,
incident was
just a minute, no, just to enter the track, notice, just a minute. So in the FIR, he has not named these persons.
no, nobody is named, my lord.
Owner is there and then initially.
Yes, my lord. And moreover, my lord, kindly peruse that the alleged incident was taken place on 23rd of July, my lord. And FIR was lost on 26th. That is 11, page number 11, bottom part, my lord.
26/7.
Yes, my lord. Why they have waited for three days, my lord?
3 days.
Moreover, my lord, I am the owner of a truck, my lord. That was, I have annexed at page the seizure memo, my lord.
This, you're owner of this truck,
I am Yodha truck, my lord.
not this truck.
Not this truck, my lord.
Yo, acha, the other one isn't.
And that has been seized after about 2 months, my lord, by the police.
I along with my friend were coming to Pastor Dorigani. There were 2 vehicles, one Alto and a Tata Jota vehicle from police.
Lordship, may kindly peruse.
So this was,
annexed
you are the owner of the truck, which was Tata Yodha.
Tata Yodha, my lord.
It is a SUV.
A small
and,
truck, my lord.
So these two is supposed to have wrongfully restrained them and tried to
This
commit
is the
dacoity.
allegation. This is the allegation, my lord. And my Yodha truck has been seized after about 2 months, my lord. My lord, kindly peruse the seizure memo that is at page 16, my lord. Annexure C. Second para, date and time.
Mhm.
The incident was alleged to be happened on 23rd of July, my lord, and on September, my truck was seized, my lord. And I am no way connected, my lord. My vehicle was hired by 2 persons, my lord. That is, I have stated in paragraph 4 of my petition, my lord. Paragraph 4, page 4, my lord. One, Samim Barbhuya and Mamon came to the petitioner and took the aforesaid vehicle under registration number so and so on hire for carrying some articles from Doboka to Fultuli Bazaar, my lord. I am not present at that incident, my lord. I do not know about the incident. After that, they have given my truck to my residence, my lord. And thereafter 2 months, my lord, my vehicle has been seized
Right.
by the police, my lord.
In the FI, my lord, reveals that the truck was taken to a rice mill, my lord. What is the version of the rice mill owner, my lord? He is specifically name of the petitioner, my lord. And that particular Jodha, my lord, they took, my lord, Erika nut from the vehicle and they forcefully took the vehicle, my lord, truck to the rice mill, my lord. But we look into the last statement of the, my lord, rice mill owner, my lord.
And this vehicle was, his vehicle
My
was
lord,
taken
he
on
in
hire
fact,
by.
his
the-
vehicle, his vehicle, the rice mill owner hired a vehicle, truck, my lord, to carry goods from rice mill to the Guwahati, my lord. It reveals.
Mhm.
But my lord, that Jodha truck intercepted the truck which is carrying, my lord, Erika nut, my lord, and forcefully took that particular Ashok Leyland truck to the rice mill. Rice mill owner thinks that the car which he has hired that has been entered in the rice mill. So he went to the truck, my lord, and he found that there is a Erika nut. It is loaded with Erika nut. That is the statement, my lord. And he particularly.
But the thing is that he is he is not the occupant, he's owner.
He's the owner, my lord. His name is there, my lord. Raj owner heard the name of the petitioner, my lord. That is specific is there, my lord. That specific.
Azizur Rahman.
Amiruddin, my lord.
No, this is statement of the rice mill owner,
Raj mill owner.
Azizur Rahman.
Azizur.
Let's see.
Lordship.
Okay, these two persons, Amiruddin and Bilaluddin. What is the owner's name? Owner's name? Huh?
Owner's name is Amuruddin and the vehicle was seized from the my lord mother.
He was present in the vehicle.
My lord.
But he said that you have stated in he's made a statement that he had given on hire.
Lordship, I was not present.
The statement on oath, my lord. But whatever the investigation reveals, my lord. And
Samin, Borbhia and Mamon.
Yes, my lord.
there are some other persons in the vehicle, my lord. Rash owner says that, my lord.
Sure.
So that there is specifically.
Facts are very confusing. So,
My lord.
I think what you do is I think I will ask him to record his statement, his owner's statement,
Lordship.
and send it back because it's not very clear. Is there any other material? Because according to him, he heard, the owner heard them calling each other by these names, Amiruddin and Bilaluddin. Amiruddin is the owner, petitioner, owner.
Vehicles were taken from the truck, my lord.
Mhm.
And my lord, the vehicle was seized from the my lord, his mother, my lord. Also look at the
But
statement of the mother.
this is this also has to be given importance because
My lord.
this is the paragraph on oath, on supported by affidavit.
Lordship.
But these two persons came and took his aforesaid vehicle on hire.
My lord.
So
That is
anyway.
only the statement.
Any other materials?
My lord, these materials and the vehicle was seized from the mother of the, my lord, petitioner, my
No,
lord.
that is his owner.
Owner, my lord.
That's
And
okay.
what is the statement of the mother? That is also important. Lord, should take into consideration that also, my lord.
What has she said?
He says that does not know, my lord, about the petitioner, my lord. That is the statement of the mother.
Mother.
Mother, my lord. Lord, should look at the statement of the mother.
Whose mother?
Amina Khatun, my lord, petitioner's mother.
Owner's statement is not there, right?
No.
Because he's seeking it.
Vehicle was seized after good.
Filing this undisputable.
Yes.
He is not cooperating. He is not.
No.
He's evading arrest from them. So this is not the appropriate case, my lord, to grant the pay.
Because,
Commission.
Because non-bailable section, how can I, my lord?
No, no,
I approve the.
Dacoity is a serious matter.
They can
yes,
and in the guise of the police, my lord, in the
no, no.
guise of the police.
No, that's true. But dacoity is a serious matter. However, the
Yes.
thing is that they're blurred. The circumfacts are still blurred to me, to
Lordship.
my eye. I don't know because who were in the vehicle? Was it actually
Yes,
hired?
yes.
What is the story?
My
You
lord.
were hired
That
by
is-
someone, and then they tried to commit dacoity,
My lord, what is my lord?
or the
FI
owner himself
the-
was trying to commit
My lord,
dacoity.
my lord, not owner, my lord. He is the my lord, the truck, also Leland truck, who is carrying the my lord, Erika Nath, my lord, that was intercepted by the car of the petitioner. And
Car of
moved
the
the,
petitioner.
my lord, car by with the car of the petitioner.
But the car of the petitioner was
It was Jodha car, Jodha.
Well, yes, that Yoda car. Who were the occupants of the Yoda car?
Yes.
The petitioner is himself is the owner. He, the Rashmil owner says that the name of the petitioner, my lord.
No, the owner is different, but if he was present, then
My
he
lord,
has
he
a
is the
implication.
present, my lord. Yeah. I will, my lord, investigator reveals the petitioner is present. Rashmil owner specifically took his name, my lord. Amiruddin. And he is the owner of the vehicle. That vehicle intercepted the Ashok Leland
No,
car.
owner can be sometimes, that suppose
My lord,
somebody is
that is
taken
only
as.
the statement. That is only the
Yes, sir.
statement, my lord. But my lord, after filing the FIR, petitioner is evading the arrest.
No, no,
Vehicle
how-
was not found. Subsequently,
Non-bailable
the
section,
vehicle
my lord,
was found in the house of the petitioner.
It's a.
I'm leaving to lord.
No, I'm not disposing it off. Let him record his version of events
Lordship.
because that will help me also,
Lordship.
or the court, whichever disposes of finally. The case arose out of an FIR dated 26/7/2023, lodged by Khairul Islam with the allegation that on 23/7/25 in the evening, he and his friend Amjad Hussain Laskar were coming from Kasar towards Guwahati in Ashok Leland truck bearing number AS25 FC 7194. Full stop. That on the way, the full stop, that so and so loaded with areca nuts. Full stop. It is further alleged that on the way, one Alto car bearing number AS12D4354 and Tata Yodha vehicle bearing number AS31 C1553 wrongfully restrained them and tried to commit dacoity. But when they were taken to one rice mill, the owner of the rice mill would save them and stuff. The petitioner is drawing attention to para 4 of the bill petition. It is submitted by the petitioner side that one Samim Borbuya and Mamon had hired his vehicle for 3,500. And later he came to know about the incident. The vehicle was seized on 26/9. 26/9. 24/9/2025. Stop. Mr. G. Chutia learned additional people. Submits that the case diary has been revealed and drawing attention to the statement of the Azizur Rahman, the owner of the said rice mill. It is contended by the prosecution that from his statement, the names of Amiruddin and Bilaluddin has emerged as occupants of the Yodha vehicle, and that the said Amiruddin is the petitioner herein. Name of the owner is Amiruddin. Stop. If he was himself present, then he may be involved. But anyway, we'll give a short date. Let him record quickly.
If the CD again required to be returned.
Yes, yes. While the petitioner contends that the vehicle was taken on hire by others, but as per the prosecution, then the name of the present petitioner emerges from the statement of the aforementioned witness as being occupant of the vehicle. Therefore, to throw more light on the matter, I deem it fit to direct the petitioner to appear before the IO for examination so that his statement can be recorded. Therefore, the case diary may be sent back and procured again for the next date. In the interim, in the event of his arrest, 25,000 with one security, subject to the condition that he shall appear before the IO within 7 days. Within 7 days, let's fix it. End of next week. Then, no, will it come? Which police station?
Lanka police station.
Lanka,
Kaki.
Hojai district.
Oh, Kaki police station. Hojai district.
Hojai district. We can take a chance. Record time before the IO, making himself available for examination, and otherwise render full cooperation to the investigation to throw light on the actual facts. This is the matter on. You can suggest 12th, 12/1, 12/12.
12 is Saturday. Oh,
No, Friday.
no, Friday.
I've seen.
Friday.
Sometimes the facts, if they are hazy, it's not a bad idea to give him an hour. Let him give a statement. Then we'll see.
Lordship, I'm very sorry to interrupt your lordship. In item number 17, your lordship, I was on leg on the other court, your
That's
lordship.
better.
Your lordship, my junior colleague appeared, your lordship, but the thing is that.
Oh, we've ticked, I think we passed some order.
Yes, on your lordship has fixed that matter on 18/12 since CD was not received. On the last date also, your lordship had said that already CD has not been received for the last 1 month. So direction was given to get the CD.
You're not, you want an earlier date.
Your lordship, if it can be advanced, your lordship.
18 days.
18/12. आपने लिखा ना? Will 15 be okay for you?
Can it be on 12, your
17.
lordship?
Okay, 12,
Oblige.
12,
12.
12. Change it, 12. Prosecution no code. 12.
77, time being.
You can take it now. Yeah. Yes, you brought on the snow.
Yes,
What's-
we have placed the, this notice under 57 is certified.
Yes,
copy.
it's better always because
Not
it's, it's-
And it's record also received.
it is always better from your side. It's always
Yes.
better and it is Decca, it's just scan copy. It is now. Could you locate the notice?
50 notice is there, Lordship. It has come, Lordship.
It has come.
50 notice without any ground
Oh,
also.
that's okay. We'll see. In the scan report.
Yes, Lordship.
Scan report. You are scan report.
Aji-
You have text something here. Scan record has come. This is
Animal
scan
attack.
record. It took a-
Malo, kindly, can we see that, Lordship? We'll mark that. Mark for us.
This is
We
not
mark.
a
We
scan
mark.
record actually. This is your petition only. This is your petition.
It is,
Scan-
it is in the petition as she is stating. In that file, Lordship.
Okay.
Ever, I think. No.
এটা কি এইটো এই আগৰ অৰ্ডাৰটো নিচিনা হ'ব আগৰ অৰ্ডাৰটো নিচিনা হ'ব আৰু টেক্সটো অলপ বেলেগ হ'ব
Oh, okay. Oh, you guys. Oh.
You have filed this affidavit. What is the trial is going on in this case?
Yes, but
Witnesses are being examined.
only
And
out
he-
of Lordship,
And he is in custody since,
since Lordship 16, 12, 20.
okay, 20 long time.
Long time.
It will complete also. Okay.
Okay. Out of 11, 5 witnesses
Necessary
examined.
also to give bail at this stage, but we are giving on 37 barrier, it's another thing.
Lordship.
Even after 5 years, even 21, you may be able to overcome 21 barrier also. Sorry, 37 barrier also, but now we are only on this.
Lordship.
I mean, lower order to three, so,
We have annexed the early order also.
any submission from your side? This earlier order was in the same case.
Same case. Only there is one typographical error in the early order. Lordship, to the
Something
satisfaction of space.
Special judge.
Special just, it is written Bongaigaon, it should be written as, Lordship, I think, Kamrup Metro, it is a three.
I usually always write therefore
Yeah,
concerned learned court, it's always safer.
Yes.
So even if you make, you know. The petitioner side heard Northeast Land Council and M. Deca Council appearing for the NCB. NCB crime 17 of 20, right?
Yeah.
It was already to order 2811, page 93 doesn't. The petitioner side has filed an additional affidavit annexing copies of the notices under section 50 CRPC as it existed then. It's full stop. He was arrested on same 14/12/20. You don't know if he to order of para 2 and 3 will be same. Para 2 and 3. So the notice annexed by the petitioner side has tallies with the notice available in the scan record and may be reproduced herein below. So and so. No, it's also available in the scan record and may be reproduced herein below.
In the early order seat also.
Yes, I've seen.
4.
Scan record, where is the scan record?
See, it is marked as N. Flag N.
Oh, yes, yes. This I missed. Oh, okay. That's why I was searching. They do, huh? Page, 50 will mark cross. 50, 50 mark. Flag is 50. Page 104, dollar 160 duta likha ase. 104, 160. Right? Stop. Then it's okay. Next para, the petitioner was arrested on 14/12/2020, and the case is stated to be at the stage of trial, during which so far 5 witnesses have been examined out of 11 listed witnesses. Charge was framed on 17/1/2022. Episode you 6-7 paragraph 75,000 with 1 security, same conditions. There's no reason to have different conditions. 6, 7, 8. But full citation be available. To the concerned learned court, which is special judge, Kamru Metro.
ADZ3. Additional
Oh,
session judge number 3.
Special judge, additional session judge number 3, Kamru Metro Guwahati.
Lordship. Deeply obliged.
75,000, no?
Lordship.
1 security.
Lordship. Obliged.
This was something. Is avoided. The other one, no? Aadhaar to. No, this is not Aadhaar. This is not Aadhaar.
No.
This is Aadhaar.
No. In the Hill Assembly,
Yes.
so one of the service as it is.
Others, no? Admissions. Okay, consoles are there, we can just quickly 24, 26.
I cannot 24.
And be ready.
26.
Oh, no. 24, can you appear?
Yes, yes, Lordship. Item number 24, Lordship, the delay condonation of delay 759 days, Lordship. The notice was issued and service report is awaited still, Lordship.
Delay in preferring a criminal revision against conviction. Appeal against the appeal.
Against the appeal, Lordship. Lordship, here, Lordship, already, whereas warrant of arrest has been issued against the petitioner, Lordship, before filing the revision, Lordship. And because of the delay and the service.
Because it's pending for that.
Yes,
Service report, no notices expect has been received back by the section till date. The respondent number 2 was the informant, right?
or at least no coercive actions will be taken. Otherwise, the petition will become infructuous, Lordship. And the punishment is only for 6 months, Lordship.
6 months.
6 months.
The interlocutory application has been filed seeking condonation of delay of 734 days in 34 days in preferring a criminal revision against concurrent findings of guilt against with regard to the petitioner. Under ultimately it was under which section? 279.
Section 2.
279.
279
304. Capital A of it.
IPC. The sentence is stated to be 6 months. And it is submitted. Your good name, please, Ms. Mishra.
Yola, Lordship.
Right. Learned counsel for the applicant petitioner submits that the interlocutory application is pending at the stage of service upon the informant impleaded as respond number 2, and during the pendency of the same NBW is already in process against the petitioner, and she submits that petition that the applicant may be given some interim relief on that. So what should we do? We'll await, Bora, should we await this one? Service, should we await?
304-279,
Mhm.
the respondent's service is not required, it stays suffused.
Not essential. It is fairly submitted by the, can I record? It's fairly submitted by the learned additional PP, SH Bora, that considering the nature of the penal provisions, it is not mandatory to notice the informant, though it may always be desirable. Did you send it by registered post? Registered post?
Mr.
And Lordship, one more section is there, that is 338 of IPC.
338, yes, injury.
79 is not there, Lordship, in the application.
304A is also there, right?
304 is there and Lordship. 338
Naturally, you know, someone of his relative has died, then we'll have, we should actually, but if we say that no coercive measure should be taken till then, no, but this is in the IA, right? But some kind of, that kind of, it's not their fault also.
Maybe
But can it be, we cannot deem it to be complete also, no, it's like 27 General Clauses Act, but criminal matter, can we deem it to be served also?
deem it to be solved also. Or Lordship may give a second chance also.
Second chance also, yes. You postal tracking, you can, or would you like to take fresh steps? Whichever quickens the process. Tinsukia, Pengri, Tinsukia, this should be possible to locate. Dumduma, Nova, Pengri, Tinsukia.
I'll check the postal track, Lordship.
You can, yeah, because that is. Await service report upon the private respondent. In the meantime, the registry may verify service, if any, from the postal tracking if available. You can just tell me, right? Till the next date of listing, no coercive measure in terms of the NBW issued against the applicant may be taken.
Highly obliged.
NBW issued dated, that will be best.
Any date, Lordship.
No, NBW issued by the order dated. Can we give the date?
Yes, Lordship. 28/2/24, Lordship.
28/2/2020. No,
And
that's long time.
Yes,
There'll be
Lordship.
subsequent dates. No, let me
Yes,
not
yes.
mention the dates.
Yes, Lord. Yes.
In GR 2290. In GR 2290 of 2012. Long time, huh? This long time. These matters, either way, this grievance. This side, both sides have grievance. Anyway, this is the matter on after vacation. Second week of January.
Yes.
Second week of January. In January, before Bihu holidays, on a date to be fixed by the registry. In the meantime, nowadays ADs don't come back. ADs have become outdated. They've become done. Don't even need to annex. It's postal tracking.
Yes, postal.
Postal tracking.
Obliged.
So do you want a date to be fixed? I'm keeping it open. I
Lordship.
can fix a date also.
Lordship, kindly fix the date.
26. Eight one,
8/1. Yes, yeah.
Thursday.
Obliged.
26.
What's the matter?
36.
Fair to say.
ওখানে নাম সই করেনি
Previous bail. Oh, no, yeah.
ওখানে নাম সই করেছে
How come there's nothing, no advocate, learned council name is shown. Or allowing to go on previous bail, but we are not filing the high court. Previous bail is of press bail, 481 BNSS. 481. What is 481?
My listed madam. Listen, nominal.
Oh, they were granted bail, most probably
Not sure.
by some appellate court.
Not sure.
Then they're filing a revision, then they want to file they want to go on bail. So I think let the
them
names of the
appear.
councils be shown.
Yes, let them appear.
Let the A Ali for the applicant. And UK Burman for respond number 2. The names of the councils are not shown in the cause list today. However, two names are reflected in order dated 1/12/2025. The names of the learned councils for the petitioner and the respond number 2 may be reflected in the cause list. List the matter on
First week of January.
first week of January. This is the matter in the first week of January, but the previous bail matter, I don't know if it come in a first week of January.
Of last week.
Date to be fixed by the registry.
Time being item 8.
Which one? Or timing man?
Learned advocate for the forest is not paid. Learned advocate for the forest department is not.
Oh,
I
that
have
is the
informed-
forest matter, right?
I have informed over.
Standing Council Forest.
Mr.
I
Sharma,
have informed-
Sharma, Mr. Sharma,
Mr.
V. Sharma,
V. Sharma, but
He's today. he's
not,
present.
he's not present today.
I informed over WhatsApp and he said one Ishan Bhattakur will appear, but.
Yeah, Mr. Bhattakur also appears, Ishan
but
Bhattakur.
I also
Inform.
send WhatsApp to him, but
He
he
will.
will appear.
Wait for some time then.
HRS
Not really.
HRS
হবো, ঠিক আছে।
দেখি তোমাকে দিব না এই নথি কন্ডিশন নথি
এইটো চাওঁ ঠিক আছে। এইটো টাইমিং ইটো টাইমিং the other timing. Because all steps আছে, we can take it forward. Diary has come in this case.
30.
Just a minute, I'm just seeing the what
But the diary-
interim bail is there.
Yes, your lordship.
There is available.
Okay. Sir will come.
Yes.
All you'll do, he will come.
For some time, your lordship.
They are on interim, diary has come. So we'll see after some time. Which logo? Which logo for town method?
28.
No, which one should we take? Admissions or this one? No, which one I'm asking? Admission, it one. I know, we can finish this. And then we'll be last. We'll finish it.
Number 2, admission item. 2, 3.
2 and 3.
May I please look?
Why is it come up for?
It is for admission, my lord, today.
Yes, I understand.
Facts of the case is there, my lord.
It is again interim compensation.
My lord.
Interim compensation.
My lord, right after receiving the demand notice, my lord,
Just a minute, just a minute. See the prayer portion. I'm seeing your prayer portion, just a minute. Against order dated 26/9, right?
26/9,
23 itself, right? Long
23.
time. So let us
Subsequently,
see,
it was filed, my lord, there was some condonation of delay, my lord.
can
In
we, okay.
disposing of that condonation of delay, my lord, it took some time. Thereafter, my lord, it was admitted and it is not yet admitted, no, it was listed, my lord.
Listed, so where is the impugned order? Can we see?
If you
26
not, your lordship will find
page.
from page 32, my lord.
Okay.
The lordship has taken up 396, my lord. There are two cases, my lord.
Yes, I am taken up, yes, 396, correct?
Correct.
32 onwards. Okay, this is the order. I've seen the order. So the learned magistrate looked at the provisions and then he said that he recorded some prima facie satisfaction. And then he proceeded to give 20% to you, right? 20% of the check was, what is the absolute amount?
Check amount is 20 lakhs, man.
20 lakhs. So that will be quite an amount, right? 4 lakhs.
4 lakhs.
4 lakhs. So you make your submissions. Let's see.
The facts of the case is, my lord, right after receiving the demand notice, my lord,
Mhm.
I have filed a reply to the demand notice stating clearly that this check is not mine. And the account that from which this check has been given, my lord, that account is also not mine, my lord. I have completely denied that the stake for which you are demanding me money, my lord, that check is not mine. Account is also not mine.
Signature is also denied.
Signature is also I have contested, my lord. That the signature is also not mine. I have also on the same date, my lord.
But that's, as you know, that is,
I have also filed
once
a-
a signature is admitted.
I have not
then
admitted.
The presumption starts,
My lord.
and then you have to rebut. But so I'll come to that.
I have also filed an FIR. An Indian FIR, my lord.
I'll see your documents, just a
My
minute.
lord.
I will see your documents. Okay. And what is the second matter about? Second
Second matter
394?
is also another check, my lord.
Another check.
16 lakhs, man.
That's also 20%.
That's also 20.
3 lakh 20, 7 lakhs 20,000. See, these provisions have been
Reply-
incorporated out of compulsion.
My lord.
That because, check bouncing matters, people have to run helter-skelter despite giving checks, whatever, in genuine cases. And therefore, these are, anyway, they have to be applied as per the guided, as per the discretion, wise judicial discretion, following the principles. And yeah, which document should I see next? You can make your submissions.
Will come to Annexure 3, my lord, from page 27. my lord.
So 3. Page 27. Yes. Yes.
This is my reply, my lord. There was an agreement
Hmm.
with the, my lord,
complainant
Hmm.
to sell his plot of land with
Hmm.
me, my lord.
Hmm.
Which I have clearly, my lord,
You were planning to buy the,
not my lord, not me, my lord.
not me, not
He
you.
has sold this plot of land to someone else, my lord, and there has already been executed. Knowledge sale deed has been completed, my lord.
Can we read this notice?
Yes, my
Just
lord.
I can go through also.
Well, from I will start from para 1, my lord.
Yes, yes, start from there.
That on 12/9/2018, your client Pranav Jyoti Deka, in the capacity of a lawful attorney of his mother, Swarna Prabha Deka, has executed a land sale agreement with my client for selling a plot of land measuring 2 kotha, covered by so and so, situated at so and so, my lord, after taking an advance consideration of rupees 5 lakhs. Later, the said land sale agreement was cancelled by both the parties, and your client, Sri Pranav Jyoti Deka, has sold the aforesaid plot of land partly to Dr. Suman Acharya and Dr. Krishna Talukdar for a consideration of 15 lakhs, and partly to Sri Hare Krishna Das for a consideration of rupees 9 lakh by executing registered sale of deed in their favor at the office of the senior sub register, Kamrup. So that plot of land was already sold of my lord. And the agreement to sell that plot of land, which was with me, my lord, that was also cancelled, my lord. And he has sold.
Duly cancelled.
Duly cancelled, my lord. And he
Thereafter, it was sold to someone
sold
else.
to my lord 3 persons for in part, my lord. And he has already executed sale deed in their favor, my lord.
The
And that
owner
is
of the
what
land was Pranav Jyoti Deka.
Pranav Jyoti Deka,
The petitioner herein is
Madhuram Deka, my lord.
Madhuram Deka.
Para two,
And Pranav Jyoti Deka was the attorney of your mother, or what?
of
No.
his mother, my lord.
Of
The
his
land
mother.
belonged to his mother, my lord.
And Madhuram Deka is, who is he in this?
Madhuram Deka was the, my lord, he agreed to sell the plot of land and find buyer, my lord.
context?
Now, para 2, my lord, page 28, my lord. That my client Madhuram Deka has no dealing with your client Sri Pranav Jyoti Deka after the cancellation of the land sale agreement executed on 12/9/2018. There is no debt due to your client from my client, nor my client has entered into an agreement with you on 24/2014 as stated in your above mentioned legal services. As such, the question of issuing any check to him by my client does not arise. That after scrutiny of the legal notice dated 5/7/2021 and so issued by you along with the copy of the check enclosed therewith, my client is convinced that your client Pranav Jyoti Deka has committed the offence of forgery by making false checks of South India Bank Limited dispute by duplicating the signature of my client in the said check, as my client has no account in the said South Indian Bank. My lord.
I see. You have no account there.
No, my lord. I do not even have an account in the same bank, my lord. I have also filed an FIR before the Hatigao police station, my lord, after receiving the demand notice, my lord.
Is it there for us to see?
Yes, my lord. That is, my lord, annexure 2, my lord, starting from page 23, my lord.
Madhuram Deka.
This was registered and the complainant is out on bail, my lord. In this, my lord. Case, my lord. Sections, my lord, under 420 and 468, my lord.
So, as I understand, this person, this Pranav Jyoti Deka, right?
Pranav Jyoti Deka is the complainant, my lord.
He was a lawful attorney of his mother.
Mother.
So he entered into an agreement with you. for
Which-
sale of their land,
For sale of
Their
his
land.
mother's land.
mother's land,
Which
and which was cancelled. Subsequently, that agreement was cancelled.
he sold that land, my lord.
No, no,
3%.
the agreement was,
And the
was
agreement
cancelled.
with me was cancelled, my lord.
Thereafter, he sold that land, his land, mother's land, to three different
Three
persons.
different persons, partly, my lord.
And then he sent you this legal notice
Yes, my lord.
saying that you had issued checks,
My lord.
and that you owe him money,
My.
right? And your contention is that you never issued those checks, and you do not even have a bank account in
I do not
Clouded,
even have a bank account in the
And,
state bank, my.
and lost the FIR for that,
My lord.
right? This is your main case, right?
My lord.
So at this stage, you should not be burdened with a
I should
interim
not be-
compensation.
I have, when I, my lord, even with their knowledge, my lord,
Hmm.
when he already knew that I did not have an account in the bank, my lord. Even then, my lord, he proceeded with filing this, my lord, NI proceedings, my lord. Your lordship, if your lordship, take your lordship to section 138, my lord.
Yes, that's section.
Clearly, my lord, here, section 138, my lord.
Yeah, that is.
When a check drawn by a person on an account maintained by him
Mhm.
with a banker for payment of any
Mhm.
amount of money to another person from out of that account for the discharge in part or in whole or in part, my lord.
Hmm.
Here, my lord, specifically from an account which is maintained by me, my lord.
Hmm.
The check should belong to me, my lord.
Hmm.
If the check itself does not belong to me, my lord, no proceedings under 138 is maintainable, my lord. And during the,
For the other matter also, you file another FIR,
my lord,
same.
my lord,
Identical fact.
same FIR. And
Two
during
la-
the trial, my lord, even the bank manager has appeared
Hmm.
before the court, my lord, and he has recorded the statements, my lord,
Hmm.
that
Come to that. And the provision for interim compensation is 140,
143A, my lord.
143. Yes.
Here, my lord, your lordship will find, your
Yes,
lordship has taken up this.
Account number is not
deposition, my-
related to,
Yes, my lord,
not related to Madhuram Dega.
my lord. The account relates to, my lord, one, Bhaspati Das, my lord,
Not to Madhuram Dega.
but not to Modram Lake. And the account is at dormant stage. The account number is not related at para 10. Account number is not related to accused.
I see. This was during the depositions.
Yes, he has deposed before the court, my lord.
Mhm.
In both the cases,
During the trial.
during the trial, my lord. And
Anyway, so
I had already submitted to judgments before your lordship, my lord, on the last date, my lord.
last date.
It should be part of the record, my lord.
Hmm.
One on section 143A, my lord. The considerations that the trial court should take into consideration, my lord, while awarding the,
This is Rakesh Ranjan.
Rakesh Ranjan Srivastav, my lord, that is on 143A, my lord.
Mhm.
The last part, my lord, I rely on, my lord, para 19, my lord.
It's prima facie evaluation and financial distress.
My lord.
Those things.
Also, my lord, merits of the case, my lord, it's a very, whereas in this case, my lord, even when I have appeared, my lord, I have stated, my lord, that this account do not belong to me, my lord. These checks are not mine, my lord.
Mm.
In that, my lord, condition, my lord, awarding, my lord, 20% compensation from me, my lord. I am not before your lordship for watching of the trial, my lord. I am willing to face the trial, my lord.
But with regard to the compensation.
I am only with regard to the compensation, my lord. If, my lord, after the trial is over and it is found that I have to pay the amount, I am willingly pay, my lord. But
No, no, the thing is that if you have never issued the check, that
My
as
lord.
per your contention.
in that regard also, I have submitted judgment, my lord. The Jugesh Sehgal versus Samsir Singh Bhogdi, my lord.
Another judgment, it's already submitted.
Yes, my lord, already submitted.
I have found this one. No, I found an old judgment. Ratan Sinha, this is a different thing. Rakesh Ranjan Srivastava, and what is the other judgment you mentioned?
There is Jugesh Sehgal versus Samsir Singh Bhogdi, my lord.
I think I was handling this file.
The lawsuit may take up with her.
No, it's okay. You can give me a spec of English if you have. Otherwise it will go from there.
In this case, my lord, the check did not belong to the accused person, my lord. And the Supreme Court has held, my lord, that no case is maintained, my lord. No case is maintainable. My lord. I am relying on para 22, my lord.
Para 22.
Para 22.
Yes. You want to read this?
My lord, I have
Oh,
given
you
a copy.
got it. I will take out, you've given it. So in this case, it was squashed.
It was passed. Since this check and the account did not belong to the accused person, my lord, no cases under section 138 is maintainable, my lord.
Okay. This much only.
This was one.
Oh.
May I please, my lord? My lord, may kindly take up section 143A for a moment, my lord.
Yes, I have seen it once. I'll take it up for you again.
My lord. This is a statutory provision, my lord. The learned court below have passed the order under this section, being empowered under this section.
There is no doubt about that. He's empowered. He's empowered and he has also recorded a prima facie satisfaction.
Yes.
But we are, as a revisional court, since he has taken the dispute to this court, we have to cross check that, right?
My lord, while framing this provision, my lord, what was the intention of the legislature, my lord? Kindly see, my lord.
But one this thing that this any cross-examination was put with regard
No,
to this.
I'll satisfy your lordship too, with regard to that also. So, my lord, it says, power to direct interim compensation. Notwithstanding anything contained in the Code of Criminal Procedure, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant in a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint. So here also he have pleaded not guilty. And in any other case upon framing of charge, the interim compensation under subsection 1 shall not exceed 20% of the amount of the check. That is also met. It is 20% only. This is also not violated. The interim compensation shall be paid within 60 days from the date of the order under subsection 1 or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the drawer of the check. If the drawer of the check is acquitted, now my lord, this is important. The court shall direct the complainant to repay the drawer the amount of interim compensation with interest at the bank rate as published by the Reserve Bank of India, prevalent at the beginning of the relevant financial years within 60 days from the date of the order or within such period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the complainant. Now, my lord, lordship will.
Yes, yes. The time frame is there,
Now, my
60
lord,
days plus 30 days.
yes. Now, lordship may kindly come to
But
page,
the-
page 35.
Yes, but the section does not say how it says when it can be exercised,
No, my lord.
right? And
The protection, I am on the protection.
yeah, yes.
Protection
is there.
given to the complainant.
Yes, but no, well, in this particular case, was a indemnity bond or
No,
was
my lord,
given?
kindly come to page 35 for that, my lord. Page 35
No,
for a moment.
I'm
This
not
is the impugn order and the last part of the impugn order. Page 35. Lordship have found page 35.
Yes, yes, undertaking on affidavit.
The complainant is also directed to file an undertaking on affidavit that he will return the compensation amount along with interest in case if the complainant fails to prove his case. Now, my lord, the legislature, while framing this law, this section, have well taken care of the fact that what if the complainant is acquitted or the accused is acquitted? So that has been taken care of.
No, the
First,
thing is that
now,
see,
my lord,
it's a debatable provision actually. It is not under challenge as a legislation, as a legislative provision. But the thing is that this, because as I said, no, this appellate amount of 20%, this has been done in the backdrop of bitter experience of complainants. But the thing is that in every case, the accused will have this grievance that he is being prejudged. You know, that is the cause. Therefore, that prima facie satisfaction, whatever is necessary.
now, my lord, lordship,
And so since the statutory section, just bear me for a moment. The statutory section does not speak of any specific direction is there for indemnity bond. So therefore, the flexibility is there. So in this case, you were directed to give an undertaking on it,
yes, yes.
right? And you gave according. You gave the undertaking.
No, my lord, he has not yet paid.
No.
Only when I receive, I will give the undertaking.
Yes, of course. He has not paid. He has come up for challenge.
So that
So,
phase has
yeah.
not come.
The directed to he has to pay within this period,
Yes.
and thereafter you give an undertaking.
Yes.
This is the direction. Yes. Fine. Next.
Now, my lord, in an NIACT case, my lord, there has to be a legally enforceable debt.
Mhm. That is a foundational fact.
Yes.
Right?
Now, my lord, there was a plot of land and the complainant and the accused have entered into an agreement. In that agreement, the complainant gave the land to the accused. And in the sale agreement, it is specifically mentioned that the accused, the petitioner herein, can bring prospective buyers. And the condition was that the accused has to pay rupees 60 lakhs to the complainant. And whatever above 60 lakhs he gets, it will be his accused profit. Now,
He brings buyers.
yes,
The
if-
buyer buys for 90 lakhs. So
30
he
lakhs
gives
is
60
his-
lakhs, 30 lakhs.
his profit.
And-
Now, my lord, this is a registered agreement for sale. Subsequently, now it is their argument that that registered agreement for sale has been duly cancelled. Write another registered agreement for cancellation. So there is no legally enforceable debt. What happened in between, that is not submitted before the court. That is in the lower court record, my lord. What happened, my lord? As per agreement, he brought 3 buyers. The accused brought 3 buyers. I'll give the names. I'll take your lordship to that relevant portion also. He brought 3 buyers, my lord. Now, since I have an agreement for sale, registered agreement for sale in favor of the accused, I cannot execute sale deed in favor of these three buyers. So naturally, my lord, I have entered into a cancellation deed with the accused. That the agreement with him is cancelled. Now the three buyers brought by him, I have executed sale deed in favor of these three buyers. Kindly come to page number, my lord.
So the agreement was cancelled with regard with him.
Yes, definitely it has to be, my
And
lord.
you sold the amount, the land to these three people
These
directly,
three persons bought by him.
directly,
Directly, my lord.
directly.
Otherwise, my unnecessary, he has to pay tax.
And then what happened?
Then, my lord, kindly come to, my lord, page number 13. Page number 13. This is from the trial court records, my lord. Page number 13. Para 4. This is my complaint petition, my lord. Evidence is in the same line. That on the strength of the said power of attorney, the complainant had undergone a registered agreement with the accused to sell the said land by document reference number so and so, dated so and so. As per the said agreement, the total sale proceed was fixed at rupees 60 lakhs between the complainant and the accused. In the said agreement, a provision was also made that if the accused, after execution of the said agreement, intends to sell the said land to some third party, then the complainant would be bound to execute sale deed in favor of the third party, if so instructed by the accused. Such provision was made in the said agreement so that the accused could sell the land at a much higher price than rupees 60 lakhs and could earn a good profit by way of brokerage. On the day of execution of the said agreement, the complainant handed over the possession of the said land to the accused. Para 5. That after execution of the said agreement dated 12/9/2018, the accused searched for third-party customers so that he could sell the said land in much higher price than rupees 60 lakhs and could earn huge profit. But the accused could not arrange any purchaser till 2 years from the date of execution of the said agreement dated 12/9/18. Then the complainant insisted the accused to cancel the agreement and to accept his advance money paid earlier. Then the accused requested the complainant to wait for few more months and stated that he has got customers and negotiation was going on with them. The accused had also placed an offer to the complainant that he would not adjust the advance money paid earlier with the total sale proceed of rupees 60 lakhs as promised to the complainant earlier, as it took a long time of 2 years to search for customers by the accused person. That means the accused agreed to the complainant to pay rupees 60 lakhs excluding the advance paid earlier in respect of the land under reference. Then the complainant agreed to the offer of the accused and extended time till November 2020. That accordingly the accused brought three customers, Dr. Suman Acharya, Dr. Krishna Talukdar and Hare Krishna Das. Accordingly, entire 2 katha land was conveyed to those customers as instructed by the accused as per the agreement, and the complainant had executed 2 registered sale deeds on 7/11/2020 through the process of commissioning in the house of the accused and instructed by the accused in favor of the said customers. The complainant was not aware at what price the accused has fixed the sale price of the land with the said customer. The complainant was assured by the accused that he would get his rupees 60 lakhs as promised by the accused earlier, no matter what amount the accused sells the land to the customer. The accused collected 2 checks from the purchaser for a total amount of rupees 24 lakhs and handed over to the complainant. And for the balance promised amount of rupees 36 lakhs, the accused issued 2 post-dated checks in favor of the complainant by check number so-and-so dated so-and-so for an amount of rupees 16 lakhs and check number so-and-so dated so-and-so for an amount of rupees 20 lakhs, both drawn at the dispute grounds of the South India Bank Limited. This is the actual story. Now, my lord, if we listen to their story, they have not brought these things. And as such, they are saying since there was an agreement for sale, that agreement for sale was cancelled, so there is no legally enforceable debt. But this is the actual story. The agreement for sale has to be mandatorily cancelled if I have to do a sale deed with some third person. So this is, now my lord, these are matters for trial, my lord.
True.
Now, lordship, I hope, lordship, I
have
satisfy you on this point.
But before, since this is there in this paragraph, so I just want, if this, you do not, this deposition, according to this deposition, this one of the check was issued on this account number,
My lord,
061, so it is not related to accused Madhuram Deka.
Well, I am coming to that also, my
No,
lord.
no, because I want a,
Have I
this is my
satisfied
query.
your lordship on this point on the
No,
legally
it's
enforceable
not.
debt?
Satisfaction will be at the time of,
My lord,
evaluation.
now, lordship, kindly come to this deposition.
Yes,
Lordship is taking up deposition for case, NI case number 59 or 58, Lordship?
59.
59.
On some Somudrajit Gogoi,
Yes, my lord.
branch manager, South Indian Bank, Dispur branch.
For that, my lord. And Lordship is taking up CRP 396.
Yes, yes. Record has come. Record has come. Scan record has come. So
Yeah,
you have
now-
given,
now
you've
Lordship
given
may
me a
kindly-
copy. I can see from here only.
Lordship, kindly come to page 21 for a moment of the CRP 396.
Page
21, my lord.
of your petition, of his petition.
Yes, his petition,
Acha.
CRP 396.
Yes, yes, yes.
Lordship will find a check there.
Yes, yes.
Kindly see, Lordship, account number is not clear.
Account number.
And if Lordship matches this account number with the account number in the deposition, kindly see, Lordship, how can we say that this is the same account? Again, this is a matter of trial.
062. You have it before you.
These are
062
not there, my.
605
Yes, I have seen the lower court.
605
There
Three-
is not clear.
30001. It is, this part is not clear.
So, my lord.
This part is, no, that's 18. What do you say with regard to
No,
this?
my lord.
Photocopying is,
Because of the photocopy, my lord.
but what still,
But the bank manager, he has stated, my lord, he knows the account.
Let me satisfy.
He
your-
has come with accounts, reports and all, but let him finish, my lord.
Now, my lord, kindly come.
no,
to
no,
the-
as he in the legal, because we are not, see, we are not into quashing. We are seeing whether because he's not been, we are not going to, just don't confuse that. We are not into quashing jurisdiction.
My lord.
We are seeing whether the interim
get it.
compensation should have been paid or not.
Lordship may kindly take up the deposition now, my lord.
Let us see the legal notice, which was the statutory legal notice. Is it there? Legal notice, statutory legal notice. What is the check number? What is the check number?
In the legal notice, they have not mentioned the account number. In the FIR also, they have not mentioned the account number.
No, legal notice given by the complainant.
Yes, my lord. That is page number 2.
Because a person may have more than one account. This account is not related to Madhuram Deka.
I'll satisfy lordship.
And when the check was issued on which account? We have to just first see. The check was issued
In the
on which
deposition-
two accounts?
In the deposition, the bank manager has stated that I do not have any account. That person does not have any account in this South India Bank. Not this account, man.
Where
Not
is it?
any account.
We
With
have
regard to
stated,
that, my lord,
Yes, yes,
my
my lord.
arguments
Where-
are still reserved, my lord. I'll make.
just a minute. Where has it stated?
Page number 27 is the legal notice, my lord.
No, in the deposition, this account number is not related to
Yes.
Madhuram Das. But he has not stated that he does not have that. That could have been a question actually. That whether he has any account in South Indian Bank, Dispur branch. Anyway, please.
Legal notice, my lord.
At,
Page 27, my lord.
yeah, I am on that. Yes, yes.
Yes.
This we had.
Kindly see, my lord.
Mhm.
The entire, my learned friend has already read the entire legal notice, my lord.
Mhm.
In the entire legal notice, there is no mention of any account number. They have also lodged an FIR. In the FIR also, they have not mentioned any account number. And my lord, in a case of dishonest check, my lord, this Rohi is not expected to know the account number of the accused.
May not know.
Yes, my lord.
Hmm.
And this is the notice, my lord. There is no account number is mentioned.
Because we cannot go into disputed facts. at
Yes,
this stage.
my lord, we cannot.
See,
And-
one thing has to be appreciated that interim compensation at this stage, at a preliminary stage, with at least to some extent, it amounts to prejudging. That's why it's a disputed provision, though it has not been set aside by Supreme Court. Is that it has its own justification. It is not a right to get to have interim compensation. There should not be disputed facts of such a nature that they require without negotiating those disputed facts prima facie. You
My-
cannot grant.
My lord, there is.
You get my point? It's not a right.
My lord, may I kindly come to the deposition for a moment, my lord?
What are the records available? Let us be, let us not go into complications. Which was the, well, let us see the checks first. What is the check number and what is the bank of the two, giving rise to the two propositions? 396, which is the check? 396, which is the check? Have you annexed? Please, 21 is the check, right? You should have annexed a more legible copy,
Because that is the
You know-
photo copy they have given me, my lord, in the demand notice, my lord.
But
This is not my check, my lord. Lordship may understand.
that is your
clearly.
contention.
That is the photo state copy of the check that we have photo stated, my lord.
Mhm.
Because he has not given me a clearly legible check, my lord. Let him produce the check. The check
You,
is
you
written-
denied a signature.
Yes, my lord, I have denied the signature, my lord. That is why I have lost the FIR, my lord. Because he has forged my signature in a check that is even not mine, my lord.
The check number is
Check number, my lord, here.
05045164, right? Dated 14/6/2021, right?
My lord, the account number can also be, my lord.
My lord, the deposition of the bank official may be taken into account. He have nowhere said that this check is not his.
The check will have to have an account. How will you pay the check?
No, my
account?
lord. On the strength of the deposition of the bank manager, he is saying that this is not his check. But the bank manager has not deposed that, my lord.
No, that is cannot depose also. And
What
actually,
he has said, my
is
lord.
that this account number does not belong to this accused.
He has also stated the check is of Bhaswati Das, my lord.
No, he has not, my lord. My lord, let us meticulously read the deposition, my lord. Kindly, my lord. Today
No,
I have appeared on
No,
this.
he has said this account number belongs to Bhaswati.
Yes. Who have asked him to bring Bhaswatis, my lord? That is there, my lord. Kindly, my lord, bear with me for a moment, my lord. Today I have appeared on receipt of someone along with documents. I am working as branch manager, South Indian Bank, Dispur branch since 2023. I have brought bank statement of account number so and so, of account name Bhaswati Das from period so and so to so and so. Exhibit P10 PW2 proved in origin. This is the bank statement, my lord. Is the statement of account number so and so of account name Bhaswati Das. Exhibit P1 PW2 is the check issued by our bank, my lord. This is as simple as that. Check issued by our bank. Whose check? Not stated. On 15/6/21, check number so and so was returned. That is also admitted that this check was returned. The statement does not reveal grounds of return. Obviously, my lord, it does not.
But
An electronic
this
message.
check is with regard to, that is why he brought this account details. Now, this check is related to this account. That's
No,
why he brought
nowhere it is
prima
there.
facie.
Nowhere it is
This
there.
account number is not related. Now, let us see your statutory notice as complainant. I want to see your statutory notice, your notice. Notice that you make the demand notice, your demand notice. Let us see your demand notice. Unfortunately, this is not there, but your demand notice as
That
complainant.
will be part in.
Yes,
in
this
the
should be
record,
there.
my lord.
It should be in the record. Don't
And
worry.
also the account number can be verified from the record, my lord.
It
This
will be here.
record
Don't-
is already
don't
there,
worry.
my lord.
59, right? I think.
Exhibit 4, my lord.
Yes. Just a minute. I will find it here. Don't worry. If we do not complete, we'll keep it part. So definitely, I mean, if the person is agreed, is awaiting payment of as much as lakhs of rupees, then he expects some payment. At the same time, this person, if suppose he has not, then obviously he'll also be totally against making any payment. So that is the issue we have to decide. These are order sheets actually, these are very relevant actually. Main thing is this documents.
Bank manager statement doesn't help him in any manner.
Let us see the demand notice. Where is the demand notice? Or your complaint petition, initial deposition. Yes,
Lordship,
this
we take
this may also help.
Lordship, I'll give
Initial
my copy.
deposition of the complainant on it. This may also help.
I am giving my copy, my lord.
Yes, yes.
I have taken photographs. I'll just
Yes,
read
yes.
from these photos. Certified copy, lordship can.
Just a minute. Just a minute.
My.
The check which was dishonored according to your initial deposition is 045-164.
Yes, 045-164, and another check is also there.
And this is the same check which he has deposed. Manager is deposed with
Yes,
regard
my
to
lord.
the same check. That is
Same
why I wanted to check from the demand. Same check,
Same.
Same check, my lord.
same check.
This is the check he gave me, which is dishonored.
And he has not stated, but he has not stated, he should have stated whether this check is relatable to this account, but he has not stated. He has stated that this account does not belong to the accused.
What is it?
In para 6, para 5 of your initial deposition in the record. You just mark it so that for convenience later you also have. And the other one is 045-163.
Yeah.
163. There is a similar deposition with regard to the other
Yes,
matter.
yes, that has already been submitted on the last date, my. I have already submitted.
The cost of repetition, I'm saying, no, these provisions for interim compensation has been made out of compulsion.
Yes.
Because the person, in genuine cases,
My lord.
a
it should
person
be
has
genuine,
lent money,
my
you
lord,
know, to help someone and he's running helter-skelter.
my
Right?
lord.
And he's running after his own money.
My
Due to these bitter experiences, these things have been incorporated. But it is our duty, all of us, councils, to apply it fairly.
My lord, that is my humble submission. Not in my lord,
But
every case is
no.
my lord.
That
it
is
has to be
your,
awarded.
of course, I have to decide, that is your contention. But your good friend, he's not convinced. He says that, it's a genuine dispute. So that is the thing we have to decide.
And my lord,
My lord,
second time, one check, my lord, they say signature does not match.
Hmm.
That means it is someone, we presume that it is someone else account, so signature doesn't match. My lord, another check, my lord, it is returned for insufficient fund. If lordship take up criminal revision petition 394.
045-163.
Yes.
That one, no? Other one?
Yes, my lord.
045-163.
Criminal revision petition 394, page number 23. The bank says insufficient fund. Their bank says signature mismatch.
not my bank. That is my condition. It is not my bank, my.
Page, no, bank, no, how can bank?
We know.
Page 23.
Both of you are good learned counsels and you already know these things. We know these things that the presumption comes, once the signature. Otherwise, if it's disputed, then you'll have to probably take help of forensics.
Yes,
Right?
my lord. Page 23.
Or some other evidence.
Page
Yes.
23. Lord,
Of the petition.
Of 394.
Yes.
Here,
Now,
394. Page 23.
You do, lady, please. Should I give it back to you or keep
No,
it?
lordship could take it.
You have a copy. But it's better to be, I'll check it from the record.
It is already in the record, my.
Should be in the record.
Because this was, my lord, on 19 April 2024.
We may not, because I am today, I am not,
Yes, yes.
because another petitioner in person, he's come from Kolkata.
My lord.
He argued his matter. The another one is there. I have assured him a few minutes, at least 15 minutes.
My lord.
So we'll close in 5-6 minutes.
5-6.
And then we'll keep it, no, we'll keep it. If you want, we'll keep it
Perfect.
further on Tuesday, Monday or Tuesday. We would have heard it in second half today. Since I'm not, I'll give you.
My lord.
We should have the satisfaction. We should submit concisely,
My lord.
but each council must have the satisfaction of making a submission. But these are all duty.
Very grateful, my lord.
No, it's okay. It's my duty. So we should, in our system today at this stage, we have to, make submissions concisely and we have to write concisely
Yeah.
to save time. So that the same time saved is available for other orders. So much payments is there. Anyway, so now I am on
Page
394.
23. Page
Yes.
23, my lord. The reason for return is funds insufficient.
Yeah, this take was written like that. Yes.
So, my lord, signature mismatch returned is something else. And funds insufficient is something else.
So that deposition also he has stated that funds are insufficient. He was returned due to insufficient.
My lord, if we go by their facts,
I get your point.
that this is not my account,
Hmm.
not my signature,
Hmm.
then here, my lord, bank admitted his signature. but returned it due to insufficient funds. That is what
That's
comes
your
from my
point.
lord.
That is your point.
Yes, and my lord, on 2 points, my lord,
Mhm.
I'll just sum up, my lord, for today, my lord. If required, we will continue, my lord.
Mm.
To sum up for today, my lord,
You sum up.
my lord.
We'll give one more day and finish it.
Yes, my lord. My first point, my lord. They are on the point that there is no legally enforceable debt. I have showed how there is a legally enforceable debt. That is before the court. Secondly, they are saying that this is not my account and the bank manager has confirmed it. Bank manager have done nothing, my lord. He has brought some Bhaswati Das account. Why he brought, there is no explanation that he brought it with regard to the check or what. He brought it, some Bhaswati Das, and entire deposition is on Bhaswati Das, my lord. And on in the last line of the deposition, what he have stated, that this is a check. Lordship, I'll just take your lordship there again. Last part of the deposition. He says the present check may be issued to the account holder as instant checkbook. We cannot rely on his evidence. So there is a legally enforceable debt.
Maybe issued to the account holder as instant check.
Yes.
Why it
Means-
was, it was answered because why there is no name.
Hmm.
In that query, my lord, he has answered because when account is open, my lord, and a person requires check, my lord,
Hmm.
then instant checkbook is issued, my lord.
To the
In
account
that,
holder.
in that
And-
instant, my lord, no name is there on the check, my lord. In that query, well, he has said, "No, not to, my lord."
In the chief, para 10, the account number so and so is not related to the accused Madhuram Deka. We are also not saying that. It may be of somebody else.
This copy of the check must be available here also, no?
Yes, my lord, it must
This
be
one, the
available.
other one,
Yes, sir.
054, that one. Where is it? Can you help me with that?
The lordship will find that.
This one. Both the impugn orders are identical, almost similar, same. Yes, this one, this one. Mhm.
Submission.
6-3, right. 6-3. Okay.
There is nothing on record, my lord, to show that the check was not issued from his account. Absolutely nothing on record, my lord. And as a Drohi, I am not expected to know his bank account also. He got every opportunity to cross-examine the bank manager. Why did he not cross-examine the bank manager whether this check is of any account related to the accused? He have not questioned.
The cross-examination is,
He-
should be also be
he said-
there, my lord, but it is not with me, but it should be part of the record, my lord.
Let's
My
see.
cross-examination.
Anyway, we have some more time for this.
To sail through using Bhaswati Das.
Anyway, well, I'll see. Yeah. The heard, Mr. Parasar, Land Council for the issue, was agreed by the order dated ... passed by the learned JMFC,
JMFC.
Kamrup,
Not Samrup, my lord, this is Nalbari. my lord.
Nalbari, JMFC Nalbari. Nalbari. Impugn order dated 26/9/2023. Invoking section 143A of the NI Act, directing payment of interim compensation quantified at 20% of the check amount. Full stop. Also heard learned counsel,
F. Khan.
F. Khan Learned Counsel for the respond number 2/complainant, who contends that the learned trial court has rightfully exercised the said, invoked the said power to grant interim compensation. Stop. The scan record is available. Stop. However, arguments were not concluded. When should I fix it? You tell, let me know next week. Huh? Don't keep it next week. Thereafter will be last week. So don't keep it.
As per
Next
lordship,
week you can keep it. We can keep it. It will be fresh in my mind,
Yes.
in our mind.
as per lordship's confirmation.
On Tuesday. Huh?
Anything, my lord.
Tuesday will be which day? Nine. Nine.
Ninth, my lord, I have some difficulty, my lord. 10th, my lord, 10th or 11th, my lord.
11. Okay. 11.
Thursday, my lord.
My lord, no.
11. Right. Yeah, 31. Matter may be kept as part of. Right?
Matter.
That bail matter we could have done, no? No, not your bail. Come, we can do your bail matter also. And another one, senior counsel was waiting. Otherwise, we'll run out of time.
Time we are away.
Fix it on Monday. Stating the entry. No problem.
Out of message.
No problem. I don't have issues with these things. Anyway,
You know, petitioner hearing is behind the bar for the last 52 days, Your Honor. Mandatory period is, I think, 60 days, Your Honor, up to 10 years, Your Honor.
yes.
60
What was
days,
it? Turtle.
Turtle, Your Honor. The ground, Your Honor. Ground the barriers, Your Honor.
Mhm.
My Michael point, Your Honor.
Yeah.
F page number 22, Your Honor. 21, 22.
All the other non-police authorities, Mr. Bhattakur, all the other non-police authorities which under, make effect arrest, like police, customs, revenue, GST, they also have to be trained in this compliance, because in GST, in the context of GST, in one case of Radhika Agarwal, this has been laid down that these arrest procedures will still be applicable, because for the person arrested, the substance means the same thing. Anyway. So you think 47 notice has been complied?
Not communicated.
Not complied.
Not communicated. You know, ground hunting turtle and cutting after turtle, and though there is a
No, that's this kind of offenses may not be, the grounds may not be so detailed also, like I say NDPS, but still they have mentioned something,
and
hunting turtle and cutting.
turtle meat. Cutting after the turtle.
That means hunting
Yeah.
and then choi means that. only.
And though there is a person for signature of the accused here, there is no signature of the accused. As far as this notice was not communicated at all. And again in page number 21, 48 notice here, 21. The person who served this notice, the designation is not mentioned. Who served the notice, that is not mentioned here in 21. In 6 and 7 column number, designation who served the notice here. Already 52 days. Apart from this, done already 52 days here.
Merits also we can see it. Case investigation, case diary you've got, no?
Case diary we got, my lord, but the final offense report has
No.
not been prepared yet.
I think it can be granted at this stage because it's been there. The thing has been, prohibited wildlife has been seized already. Right. Turtle,
Some condition.
Obviously.
First offense here.
obviously. Heard Mr. Neog and I, Bhattakur Learned Counsel, Special Public Prosecutor for the for Forest Department Wildlife Offences, invoking section 483, the petitioner is, both the petitioners are seeking regular bail in connection with offense number so it has a last order. So it's always this. They were arrested on 15/10/2025. The allegations is about hunting and killing of prohibited turtles. Stop. The Mr. Prasad Mr. Neog Learned Counsel drawing attention to certified copies of the notices under 47, 48 BNS contains that the same are deficient and do not meet the stipulated standards. Full stop. The notice under 47 both the notices mention hunting of turtle and cutting of turtle, italics, with in the column pertaining to grounds of arrest. Full stop. It is also contended that the notice under 47 does not bear the signature of the accused, and the one under 48 does not indicate as to whom it was furnished. 48 notice is also a of annexed, right?
Yes.
To whom it was. No,
20.
I think it is informed. It is there. Rikamoni.
Inform.
Inform. It took it. No.
Designation who served the notice is not mentioned.
See. I find that though the contents of the notices do not have much details, but it is also not a case of the notices being bereft of any grounds of arrest. Instead, it is submitted by the special PP, learned special PP, that offense report is not yet submitted. Offense report, right? Final report. Final offense report has not yet been submitted. Considering the progress of investigation, the seizure of the prohibited wildlife, and the length of detention within bracket 52 days dash, both the accused persons are hereby allowed to go on bail of rupees 25,000 each, with the right surety of the like amount each to the satisfaction of the concerned learned court, which is Punitpur. Session Judge Punitpur. It's concerned learned court. Concerned learned. Gopur, SDGM Gopur, probably is SDGM Gopur. And subject to the following conditions. Number one, they shall cooperate with remaining investigation. They shall not hamper or tamper evidence. They shall not misuse their liberty to commit any illegal activities, including any activities prohibited under the wildlife law, wildlife and forest laws. Violation might entail cancellation of bail. Return back the case diary. In petition stands allowed in this first stop. These are small turtles or big ones? Small.
The seizure.
282 kilo,
But
big ones.
but not seized from me.
Timing.
Lordship, I am appearing, my senior counsel is writing, but he is again going to clear your Lordship. Petitioner is already appeared, your Lordship, before the IO. The matter, affair is page number 9, your Lordship. May I read?
Just a minute, with diary has come.
Petitioner, my lord, after the interim order, he has not appeared before the IO.
He has not appeared. Let him appear then, I have some. I was thinking that we can fix it on Monday while extending the entry. That is, I was thinking.
Yes.
But if he has not appeared, why he should appear then? Why? He may have appeared. He's not recorded. Has he appeared as per your
Lordship,
instruction?
as per my instruction.
He has appeared.
He is appeared and certified copy of this honorable court already
Was submitted.
given to the IO,
IO.
but IO neglected.
They also remain very busy, sometimes law and order duty and all that, whatever. There should be something, that to
Let him
record.
appear, my lord.
So what would you send it back
We'll send it back, my lord. Let him appear.
and get them,
7 days time may be granted to appear.
get it, within
My lord,
10
we'll
days.
fix it, my lord, the first week of January, my lord. Because
It depends on if it's a serious offense, then serious allegations are
Right,
there.
but they-
It may not be prudent to give so much time because we do not know what will be the final outcome, right? Is an assault case? Yes.
Assault.
Grievous injury.
Fix it on 3rd week of December, my lord, this month.
Yes. 3rd week or 12th or 15th?
No, my lord, if lordship is grant him 1 week time, my lord. This is from my lord, to brief,
No, I'll not say 1 week. You'll appear as soon as possible.
my lord. Then, my lord.
The case diary is received. The learned petitioner counsel submits that as per his instruction. Your good name, please.
M. Hussain, your
M.
lordship.
Hussain, heard M. Hussain, लिख दी, additional PPRJ board. Though the petitioner counsel submits that as per his instruction, the petitioner has appeared before the IO. The case diary has been received. The same may be returned back. You'll return it back, right?
Yes.
To be procured again for the next date. In the meantime, the petitioner shall again appear before the IO, making himself available for examination. Interim bail stands extended till the next date of listing. Is the matter on
19th.
last date? No, don't keep it for last date.
There's no 17th.
Keep it for middle date. No, 17/12. Done. Please come, Mr. Agarwal. You complete. Adam, huh? Huh? Who Manish? Ah, you want to say something?
No.
Manisha, no, see. Yeah. The IA matters, huh?
It's for urgent listing of a criminal petition, your lordship.
Okay.
So actually what has happened is that the summons has been issued to the petitioner, but the petitioner, he's suffering from a degenerative muscle dystrophy, which has aggravated to 80%, your lordship. The matter is fixed on the 10th, your lordship. So I'm just.
Got a
wait-
code below.
Yes, your lordship. So
Okay.
if you're.
You want it today?
No, your lordship,
Monday?
on Monday.
No,
Yes, sir.
no, that's not a problem.
Obliged.
I thought if it's extreme urgent, then we have to do something today also. But Monday, if it's okay, no. problem.
Yes, yes, your
No
lordship. Much obliged.
Yeah.
Lordship.
78.
Lordship, on the last occasion, I had placed my submissions. In IS 799
Yes.
of 23.
That is part heard.
Lordship. Lordship,
Should we, I take up that one or? the
Lordship,
new
I
one?
just wanted to place that Iqbal Singh Marwa judgment, which was not placed before this court. on
Wait, I
that.
noted it down.
Lordship, I have the entire judgment. with me.
You can give it to me. That's an important judgment for you.
Lordship. It's a 5-judge bench judgment.
Constitution bench.
If I may read just 4 lines of it.
Yeah, yeah, no problem.
The 5th line in para A, Lordship. Maintainability held, the said bar would be attracted only when the offences enumerated in section 195, subsection 1, subsection B, subsection 2 have been committed with respect to a document after it has been produced or given in evidence in a proceeding in any court, that is during the time when the document was in custodia legis. The court was in custody of the document. If such offence is committed prior to its production or giving in evidence in court, no complaint by court would be necessary. And a private complaint would be maintainable.
So that is your contention.
And the authorities hold ground till date. This is the judgment which says that if you have done forgery before coming to this court, the private complaint is sustainable. With this, Lordship, I complete my submissions in IS 799 of 20. Now, today, Lordships have granted me time for my submissions in IS 665.
So their part I have to hear. No?
Lordship.
In that part heard IA, your part I have to hear, right? So I'll give you proper time. No, we'll hear it on next day. Or what will be the right thing to do?
To argue, Lordship, they
Because,
can.
yeah, because I can, because I'm not sitting in the second half today, except for one delivery of order. But I can extend it by 10 minutes. You can, if you want.
So for this
We should,
IA,
let's- how, let's plan it, what will be best.
Well,
One
I
IA is, we have not
Lordship, we
started.
can do it like this. Let him reply to this, so we complete one IA.
Yeah, that will
The
be-
other IA, Lordship, can take on Monday. I will stay back. I will complete my submissions on Monday.
Monday I have one.
No, in that you are not there, sir. In 665, you are not there.
when are you coming next?
No, I will be staying back, Lordship, because I have filed one IA challenging the criminal petition yesterday, which is not here before.
Monday, sometimes list is long. I don't know what would be the number of matters. Monday or Tuesday, maybe.
Lordship.
Okay,
799.
that will be better. You
Yes.
can just start If you can complete, fine, otherwise, we'll keep it part, it will remain part third at your end.
Just, what is this IA for? Basically, this IA is seeking cancellation of the bail
Mhm.
order, which was passed on 6/10/2020,
Mhm.
whereby that pre-arrest bail was allowed to be.
Mhm.
But if you see that pre-arrest bail, all the contention which is put today before this order, that the basic contention that the same ground which is being raised here, that is part of the ground that was made during the hearing of that bail application. The ground, because in that bail application, he filed one counter affidavit. May I take the counter affidavit? My lord will find it in number 133 of the IA.
799, right?
Yes, my lord.
One 133.
Page number 1. Para 4, my lord.
Mhm. Yes.
May I read, my lord?
Mhm.
Then I said that Annex 3, which the applicant has stated to be a piece of agreement purportedly executed between the applicant and myself, is a forged agreement. And as soon as I came to know about the same, I have lodged an FIR against the same before Latasil Police Case Station, so and so. Now, my lord, this particular plea, which is being taken in this IA also, this plea was already taken at a time when the bail hearing was taken. And after taking into consideration that plea, the ground that this agreement was allegedly forged, that ground was taken by the learned single judge. And after taking consideration all the materials on record, my lord, the learned single judge came to the view, because this entire issue came out from the civil transaction, my lord.
Mhm.
This is come of the commercial transaction, my lord. And considering that this is of a civil nature of case,
His main contention for seeking cancellation of bail is that one of the reasons why the court was inclined to grant bail, his contention,
my lord,
is that this was an agreement and indicated civil kind of nature of dispute, and there was an agreement, and therefore the court was inclined to grant bail and was accordingly granted. But that agreement, according to him, was forced, and therefore the bail was taken on a mistaken fact,
now that's it. Now the question comes.
and hence vitiated. That's what it says.
Now the question comes, my lord. Now the question comes, my lord. This particular ground, that's why I'm submitting, my lord, was already taken. Was this the learned single judge has taken into consideration that plea already, my lord? Now, my lord, can it be taken again?
Well,
Because there is a bar under section 362 of the CRPC, which prohibits review of any order passed by the criminal court. My lord, the law is very clear. That's why, my lord, before coming to the law point, my lord, now may I take, my lord, the grounds of seeking cancellation, my lord. Thereafter, I will address the law point, my lord. What are the grounds, my lord? Kindly come to the page number 35, my lord, of the IA, my lord. Para 17, my lord. Para 57, my lord. 57, 58. These are the, my lord, grounds seeking cancellation of the bail, my lord. I'll just read out, my lord. Then the grounds for consideration of cancellation of bail to the accused are as follows. Now, my lord, number 1, gravity of the offense, severity of punishment, requirement for custodial interrogation of accused, possibility of the accused tampering with the evidence or witness, criminal contempt of court. However, all the said requirements were completely overlooked by this honorable court. The interim order granting fails to consider the enormity of the offense and resulted destruction caused by it to the life and liberty, so and so. The interim order suffers from non-application of the judicial mind also, non-consideration of essential conditions to be considered in respect of prayer for bail made by the accused person, so that para 58, my lord, that the grant of bail, though being an order discretion nature, the same calls for exercise of discretion in a judicious manner and not as a matter of course or routine or mechanical. The Honorable Court, while granting, is required to apply its mind to the facts and circumstances of the case and materials available on the record, and therefore express its view through a speaking. The speaking order is liable to be so and so. Now, my lord, from this paragraph, my lord, what I understand is, my lord, it is something he's filed an appeal before the Superior Court, saying that my lord knows that there is two ways, my lord. In case if the order suffers from any perversity or arbitrariness not following the law or wrongly granted, the remedy is to file to approach the superior. Because review, my lord, but because 362, my lord, CRPC is very clear, my lord. I will submit judgment on that point also, my lord, which prohibits, my lord, review of anything. Now repeatedly saying, my lord.
No, cancellation of
Cancellation
bail
that
order, as
subsequently,
you know well, very well,
my lord,
that
supervising-
cancellation of bail is in a way, an exception to the power of review, in a way.
that is
Because criminal court cannot review, except typography review, right?
that's, my lord, cancellation can come two way, my lord. Perversity cannot be done by the, my lord, same court, my lord.
Can we see sometimes it helps to go back to the statutes
My lord, my lord.
again and
But
again, you know?
before that, my lord, one more
Yes.
submission, my lord.
Then, after you make that submission, let us read together the statutory provision regarding cancellation of bail, 439(2). We can read the BNSS
My lord,
equivalent, okay. Now, but before that, you make your submission,
Yes.
which you wanted to.
Yes, my lord. Now, my understanding, my lord, my submission is that the law says, my lord, 439(2), a bail application will be maintainable only when, because of subsequent supervening circumstances, my lord. Like in the case I have violated some condition of the bail, my lord. Certain circumstances cropped up, my lord, whereby there is necessity for the cancellation of bail, my lord. Then 439(2), power can be exercised, my lord. Then, my lord, there is another case, my lord, where you are challenging the legality, validity, and perversity of the bail order. Now, what is this IA, my lord? This is not the IA where it's saying that certain supervening circumstances has occurred, warranting the cancellation of the bail, or I have violated any condition terms of the bail, or that's why this way. Now, what this application is all about, my lord, is saying that the bail granted was not done as per the law. The Honorable Court did not look into the severity of offense, all those things. This plea cannot be raised again and again, my lord. Basically, this distinction is very clear cut, my lord. So I'm not on the point, my lord, it cannot be cancelled. It can be cancelled by the same court which has granted the
Can
plea.
be.
But there is a limitation of that power. Parameters are very different, my lord. And here is the case, he is challenging the perversity of that order.
So that, according to you, this law lies outside the ambit of cancellation.
Yes, my lord, exactly, my lord. Now, because I have, my lord, just read out the grounds, my lord.
Yes.
What his ground? His ground is basically saying that court has not taken into consideration those severity of the punishment, nature of the offense, my lord. This has already been taken into consideration, my lord. Nothing in the grounds of cancellation where he is saying that certain circumstances has cropped up, or I have violated certain condition, whereby now keeping me enlarging on the very quickly, one fact. My lord, this case, my lord, FIR was filed in 2018. 2018, 9 years, almost 8 years, 7 years back. Then I was granted bail 2020. During that time, my lord, police, my lord, undertook the investigation. Could not found anything. Police filed the final report. After investigation, police found that this case is of the civil nature. Therefore, police file a final report. Then protest petition was filed. That was allowed, my lord. But till today, it's going to be almost 7 years, man. 2018, 7 years, man. Till today, police have not even filed a charge sheet, my lord, in that case, my lord. This is rather a case where I have instruction. Definitely, I will go for the quashing of the entire case, my lord. This for last 7 years, my lord, it's just this matter is being pending, and And very interesting, my lord, the petitioner has approached this honorable court in the year 2024. 23. After, my lord, 3 years of granting the bail, my lord. 2020, yes, 3 years, my lord. Now, the entire, and that too, the ground of bail rejection, the ground seeking bail, my lord, that is not tenable, legally tenable under the law, my lord. Now, my lord, my another submission. First, my lord, not maintainable since there is a bar of section 362 CRPC. First limp of argument, my lord. Since review is not permissible,
Yes.
and his issue which he is raising today, that was already taken into consideration at that point of time. Had it been the case, my lord, that at that point of time he was not aware about this particular forgery at that point of time, then subsequently he came to know, then he could have raised that issue here. You at that point of time, you did not, I have no knowledge of the thing. Subsequently, I came to know about this one, that this is a forged document, you have used it. Then matter would have been different. My lord. This particular plea was considered, my lord. Now question comes, my lord, again, it can be reconsidered, my lord. Now court's observation already there in the, my lord, bail order. That case arises out of the commercial transaction. It is of the civil nature, and considering the nature of the case, my lord, even the punishment all are below 7 years, my lord. And definitely, my lord, this is the case where my custody was highly required at that point of time. So considering all those facts, my lord, taking into consideration his submission also, this court has come to a definite conclusion that where I am entitled for a bail and case prima facie appears to be a civil nature, that conclusion is already there, my lord, in the bail. And he has not put to challenge that whether the order suffers from illegality or perversity before any higher form. So now that can we go and, my lord, repeat and scrutiny the say order, my lord, passed by the another coordinate bench, that opinion, and come to a different opinion? No, this order, the earlier bail order is wrong.
I get your point.
Yes, my lord. Now, my lord, another point. This applicant, my lord,
Yeah, let me see. What is the equivalent section of BNSS now? 430, I keep forgetting. 439(2), what is the equivalent section now? Usually,
now, my lord, since
483.
the application was filed at
Yes.
the time when CRP was there.
yes,
So
in 2000, you filed it at the time when
yes,
you was
now
CRPC.
will be governed by the CRP.
Then it's okay. It's a very bland, the statutory language is very short. Right?
And this has been my
High
lord,
Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to custody. Nothing.
this has been interpreted.
Case laws.
Yes,
No.
this has been interpreted in various judgments. My
Yes,
lord.
yes.
I will place two.
We have,
judgments.
as I understand,
Yes.
that you correct me,
Right.
both of you, is that I'll set down we are actually, this adjudication rests on two basic points, in my opinion. One is that the document on which he is basing his contentions, whether they are prima facie, because that is a subject of investigation, not to talk of trial, whatever, irrespective of the delay, whatever. Whether there are any prima facie materials to indicate that that document is not genuine, number one. Number two, if there are, if the first question is answered in the affirmative, that is, if there are prima facie materials to indicate that document is not genuine, then whether on that ground the power of cancellation can be used. That's the issue.
That my lord, by submission.
And maybe another one you can fit in between the question, in between.
My lord, that's
That
why-
whether the decision of the trial court, this court, bail granting court, was primarily, based on that document, influenced by that, inclined, that is the second, that's a question in between. Yes. Now you proceed.
Yes, my lord. On that point, my lord. Now, my lord, therefore, my lord, now this issue, particularly this about this alleged forgery, my lord, this issue was considered. This issue was considered while granting the bail. Because this is the plea raised, my lord, during the hearing, my lord.
Okay. Oh, forgery, this aspect was considered at the time of the
That's
bail.
why, my lord, counter affidavit, I have just read it out, my lord.
So this, because this was according to you contended even then.
Yes, my lord. It's a part of the record, my lord. Now, my lord, once that argument was considered, and even, my lord, considering that one, bail was granted, my lord. Now, the question is that, suppose assuming, my lord, now the issue comes whether the coordinate bench can again sit on the same thing, which prohibits that it will amount to, my lord, review only. Because earlier coordinate bench has not considered. So consider, which is basically prohibited under the law. Now that's why I said that what is the remedy here? If he feels that that bail order suffers from any perversity or illegality, the remedy is to approach the higher superior court. That is only the remedy. This is very plain, my lord, so much judgment this has been interpreted. So otherwise also, my lord, apart from this aspect. Now,
Interference with the merit of the bail order has to be taken to a higher forum.
my lord, only, my lord, when it can be by the coordinate bench also, but the ground not in this way. Perversity cannot be raised. Might say that, my lord, there
The
are
same bench, no, the same level of court can probably only invoke 439(2) cancellation.
It can cancel, but the grounds are, my lord, supervening circumstances, subsequent events, my lord. But how, my lord, legality and perversity can...
That is my point actually. Whether the powers of cancellation of bail can be exercised when the bail is, apparently based on a document which is prima facie appears to be not genuine. That is the point actually. That's why I said 2 points. Whether the prima facie materials to indicate that the document is not genuine, the bail granting court used it as an important material to give that order in whichever direction it was given. Thirdly, whether if these two things are done, then next question is whether a bail can be cancelled due to fraud, which his contention is that, as we all know, fraud vitiates everything.
Yes.
So bail should be possible to be cancelled if it is based on a document by misleading doubt. That is his contention.
Yes.
I have to keep an open
Yes.
mind.
So my submission, my lord, might take...
There may be case laws. I mean, you have submitted, we have to take guidance.
My take on that point is, as writing, that the same argument was already heard.
Just I have noted down.
Yes. The same argument was heard. My lord, now the question is that can it be repeatedly allowed to make again and again? It will happen what? Suppose today also this honorable court says, no, considering the matter, I am inclined to allow the bail. Now, this argument has already in place before this. Can he again say, file the bail application for cancellation? No, this is again fraud. Because once that plea was taken, my lord, but you cannot take that plea again and again.
Okay. That is an interesting
Yes.
point, doesn't it?
Now, another, apart from this also, my lord, considering the nature of the case as on today, 7 years more than, my lord, nothing happened. As on today, no charge sheet, my lord. Now, that itself shows, my lord, nothing is there. And, my lord, considering nature of the case also, my lord, is the case where, my lord, my custodial interrogation is warranted at this time, my lord, after 7 years, even leaving apart that part also even. And so far, the argument that this document is forgery, my lord, Latasil police has filed one charge sheet. I have put to challenge that entire charge sheet and the order taking cognizance of the case, which is also listed together. That will be, my lord, I think next time we'll make the argument on that point. Because I have raised their issue that in the manner in which way the investigation is, no prima facie case, that is what the contention for a NITU application I have filed, my lord. Challenging even that police case. Now, my lord, so far cancellation, my lord, so far cancellation of bail 439 is concerned, my lord, too. The settled proposition of law, my lord, unless some supervening circumstances, like, my lord, this fraud plea had he not taken this fraud plea at that earlier point, then definitely it could have been argued here, my lord. And law says, my lord, in that case, my lord, coordinate bench can definitely go in. That is there. Now, there is no allegation that, my lord, even my lord has seen ground of cancellation. He has not read about this fraud event. Perversity, he is talking about all this perversity while passing the bail. Learned single judge has not taken into judiciously, not exercised the power properly. Not those grounds he has taken, my lord. Now, my lord, then some two judgments, my lord, just to place that
Place
when perversity comes, you have to approach the Supreme Court. And
You can place it to me.
yes, I'll just quickly address.
Just before, you have submitted a lot. I've kept it properly. Was any judgment? Do we have any? Could you come across any judgment where says that on if bail is taken through fraudulent document, that bail can be cancelled? You have submitted.
I have placed that Bilkis Yaqub case.
That's a
Suppression of
huge
fact.
one, Johnson. Yes.
Lordship, it takes care of two things.
No, no,
Now, when we say
I'll give you a chance to reply properly on the next day. So I'll go through. That's a landmark judgment. The Honorable Supreme Court.
My lord, 2026.
If you have the hard copy, I will take it, and then we can resume our this thing next.
1995.
From a district criminal court, even someone seeking interference with a bail order on the ground of, say, perversity or gross error,
Yes.
will probably have to invoke the 482, the inherent jurisdiction, because bail is an interlocutory order. So it's not revisable.
I think
Criminal division.
459(2) even can be, my lord, if any order passed by the let's suppose, my lord, the session judge, my lord.
Yeah, maybe.
Then it says that my lord
Yes.
can always sit on that
That can
order,
be,
my
yes.
lord. That
Yeah,
is
you're
permissible.
right. That we have two remedies.
My
Actually.
lord, that para 4, my lord.
It can be a IA like that, or it can be 482,
Yes.
or maybe both read with something. Yes, undoubtedly, cancellation of bail is a serious matter. No?
It's a serious matter, my lord. It needs to have a very
It has to be
circumstance.
it is no, I mean, strong or whatever, certainly not weak. But it has to be properly adjudicated. It has to be thought of and wise judicial discretion on relevant materials. That has to be there.
14 judgment has dealt with all these aspects, my lord.
Go through.
459(2) as well as, my lord, perversity, illegality, legality, how the bail application has to be considered.
This
2014-10 SCC.
Abdul Basit.
Yes. Yes, thoroughly comprehensively discuss all the issues, my lord. Then, my lord,
So shall we keep it part or this one? We'll keep it
this,
part or?
my lord, this is
Yeah.
almost the argument, my lord.
Yes, yes. You're okay. You have submitted it. Rest my homework. Yes, yes. Okay, then we.
So far, that part, like whether this that document is forgery or not, my lord, very interesting.
But he has to give a
I
reply.
have raised that issue. I have challenged that one entire, my lord.
Okay. So I'll keep it for your reply. Since you are here, you're extending.
Lordship, I will be here.
Because they will be going for lunch. No. So I have to deliver one order at 2. Otherwise, I'm not sitting in 2. I'll be doing some. So Monday we'll take it up. Your reply. What time you prefer to?
Lordship,
what-
to your convenience, I am available.
At 2 o'clock. We'll take his. What time should I take his reply? Your convenience.
I won't be available here on
You
Monday.
can take it on
Monday.
BC, sir,
Yeah.
Okay, I'll take. You can join on BC from Itanagar.
because he has already submitted. Lordship.
Okay. So what I'll do is.
Well, Monday I will have some difficulty, I have some another
No, sir.
commitments. my
Because since he's come from Kolkata.
Lordship, let us be very fair to him. On Monday, my lords can take my submissions in IS 665. His reply can be done on Tuesday.
665.
That is not your case, the other case.
Not my case.
No, they will come together actually. They are tagged. So Monday is not convenient for you.
But so far, this case
Just to join on BC, will it be okay for you at 2 p.m.?
2 p.m. my lord, I'll be somewhere in district, my lord.
Okay.
So remote
Connective
area, then
is- I understand.
Arunachal, very remote.
No
area.
issues, no problem. Then
Since for this IA, my lord.
let me fix it. Let him do the reply. Then this will, his reply will complete this argument. One of your junior can maybe just track. If something needs to be, well, you may have to say something to that, his reply. Or you would, what did you suggest? Should I take his reply and close it?
My lord,
Oh.
close it, my lord, ultimately.
Need not linger. So Monday, 2 p.m., his reply. That will conclude this one.
Yes.
And for the next one, you take a mutually convenient day.
Next one, he is not here in 665.
Oh, he's not here.
Lordship, in the criminal petition, yesterday I have filed on IA, which can be taken up on Monday because I'm the petitioner in that time, challenging the maintainability of the criminal petition.
So that has to be tagged with the criminal petition.
It is there, Lordship. If Lordship kindly pursues the.
We should resolve these things, whatever needs to be filed, have to be filed, but we also have to be, you have to be careful also yourself not to get into the trap of, multiple litigations, because it needs to be stopped, because people do get into it.
Lordship, what has happened when he is challenging?
No, what, if you have to ventilate the
I-
grievance, you have to file a.
What I have done, Lordship, when I brought to my Lord's notice that an agreement with my mother is found to be genuine by an FSL, I filed that IA before my Lord's today, which is 1308. It can be called for on Monday. Now, I indicated if I am an Indian, I cannot be called a foreigner. So the proof of my Indian citizenship is there in his own petition. His entire argument falls over there also.
Then, my lord, this IA, so far, my lord, so far IA 1308, my lord, this is for the criminal petition 558, my lord. So as on today, I have not received that.
Lordship, he is from Itanagar, he is
I
Guwahati
take
council
the-
were served.
I
And
will
only
take
then it
the,
was
I will
filed.
take the copy. my
Please make sure
and
that.
I will
Yeah.
reply, my lord, and I need some more time for my lord, this. Then, my lord, this criminal petition, item number 29, my lord.
Kindly indicate the dates to him.
Lordship, allow me to make my submissions. He will have sufficient time to file his affidavit, reply.
On the new matter.
Yes, yes.
On the new IA or
On
the
the new I am the petitioner, I am the applicant. Let me be heard.
IA number?
1308, the last one, Lordship.
Well, that's a new one.
Yeah.
So
You
130.
have enough time to file his affidavits and reply.
Make your preliminary submissions. We'll
With
hear.
that IA effect.
But give him a chance to file a counter.
He will have.
We must give, right? So otherwise, the first task before us is to complete your reply,
Lordship.
and then we close this.
This item number 29, may I pray this?
Can it be decided without the other matters? All have to be decided
Lordship,
together.
If my IA is taken up, it will help in deciding this.
No,
790.
suppose this bail cancellation is decided, then the others also have to be decided together.
Not
No, not necessary.
So far, my lord, this item number 29, criminal petition, which I am challenging that charge sheet and the entire case, my lord. This may kindly be fixed, my lord, if it is possible, February 6, my lord.
February.
Or January 28.
Lordship, the IA has to be heard. If my IA is allowed, the
No,
petition.
no, I am
goes.
not on the IA.
The IA is with criminal petition, sir.
Then without hearing me, it will never go. Of course, my lord will give me chance to make the argument. My criminal petition is my petition.
I would
But-
request both sides to, it's been lingering since lingering since 23 does not look good for the docket also. So let us try to dispose it off. You can take it. I would encourage you to take it in January, preferably before BU.
Would you, then my lord, 7.
7 or whatever. The date I'll leave it to you. No
Yes,
issues.
7.
Then I'll have some homework during BU also. It'll make sure that I'll have to study.
I wish that we close it in this calendar year, but the learned council wants to prolong it. for
Anyway,
years
just
now.
indicate the dates.
Lordship,
Now we'll resolve it.
Lordship, we are taking up IA 1308 on Monday, I sir.
Well, you make some preliminary submissions, but he will have a right to
Yes, yes,
file
yes.
the account.
That has to be retained till Monday.
You retain till Monday. Since today is Friday, till Monday. On Monday, we'll take a fresh call on that.
Lordship, the printout of the Latasil trial case is not available in the records, though it has been received through email.
Received through email. No, it
Lordship,
must be in
on
the registry.
26/11.
It must be in the registry then.
So a print can be had on Monday.
They will bring it. But we are still not in that, we use hard copies only, okay? Sure.
29, 30.
You are for the informal,
For the respondent.
for the response. The bail petition is dismissed at this stage.
Much of it.
বাকি তো বাকি
Matter number two.
ল'ব নোৱাৰিম actually, just only delivery of orders হয়। I'm actually off in the second half, but otherwise I just take, what is it come for? Service respond number 2,
That is the right.
complete?
That is the right.
It's complete, my lord.
Complete, no?
Complete.
This is complete.
So that your lordship may heard the matter at length. Since matter relates to misappropriation of money of minority scholarship, a petitioner at present discharging his duty as a deputy inspector of schools. And
Don't you think it require a full hearing?
My lord.
Full hearing it will require, right?
My lord. The Lower Court, next date is 16th the month of January. First week of February.
Interim order is there?
No, my lord.
Interim order is
So your lordship may kindly accommodate me prior to this.
If it requires extensive time, then it's better to, because otherwise hearing day again, hearing matters are also there, right? Anyway, we'll work out for the timing, this service is complete, no, in the meantime? As per office note dated 19/11/2025, service upon respond number 2 is complete. None has appeared so far with regard to, on behalf of the said respondent. Good stuff. Then when should we fix it?
As per the convenience of the court.
Lordship's convenience, my lord.
No, not really, I mean. But
If possible, my lord, 6th, my lord.
will it require a very extensive hearing will require? It will require then,
45 to 1 hour, my lord, I will take.
because on a hearing day, because hearing matters will be there. No? Because short matters which can be, disposed of by hearing of say 20 minutes, 15 minutes, those two should be disposed of at the stage of admission. But otherwise, what is hearing for?
My lord,
But I understand, once you fix for hearing, but nobody wants to be listed for hearing, actually some matters which are compulsorily and essentially, and necessarily fixed for hearing, like criminal appeals against conviction, they get delayed. They get delayed actually. Anyway,
I will finish it within half an hour to 45 minutes, my lord.
how about admitting it and fixing it on a hearing day? Then it will come 25, no? It will come chronologically, because but matters get this mentioned also, no? It may reach also.
But I have no stay order, my lord, that's why I am, the lower court have already issued summons and petition already appeared before it. And next date is for framing of charge, my lord. And on 1/8, my lord, your lordship already observed that the matter may be disposed of as early as possible and the shall be made.
It all depends on, how much time is, as I said.
I will take only 45 to 1 hour, my
No,
lord.
because see, in my opinion, anything that requires more than half an hour it's meant for hearing actually.
Yes. Otherwise.
Mm.
And accordingly, I have also prepared, my lord.
So if we will fix it on this thing. On 10, not on hearing day, 10. Then we can, if we finish other matters, why I'm fixing, if we finish the other matters on that day, then we can, that way we are not disturbing hearing matters also, and we can take time, then we can take time. And another thing is that these matters, say, suppose you fix on a hearing day also, now even if it is not, suppose you need 1 hour also, it can be half an hour and 2 days. That way you make space for others on that day. Half an hour into 2 days also it can.
I don't want 10-1.
10-1.
10-1, it's a Saturday, my lord.
No, 10-1.
It's a.
No, you said, I said 10-12. If you
Oh,
said
10.
you wanted, no, you wanted.
No,
next week.
sorry.
Let us,
10.
10-1, if it's okay in the first.
No,
week.
my lord, I'll be there. 10, 11,
Huh?
10, 12. Huh? 9.
9-1.
12, my lord.
No, not 9. 10-12 or in the first week of January.
In that case, my lord, 10, 12. I have no interim order.
Okay, okay. First
12.
chance, let us take on that day. If it's not
Yeah.
completed, then maybe.
My lord. Oblige, my lord.
Your lordship, today we have had an objection lordship from the respondent informal lordship. Let it come up with the that of the affidavit lordship.
It's not on record.
Yes, lordship.
Record,
What is
we have
record? Not today,
selected
fine.
the taking cognizance of the agreement.
Washing, eh?
And the father and brothers of the main accused against Foxo, my lord.
Yes.
That is the case. The lordship, in fact, my lord, lower court date is fixed on 10th of December.
Yeah.
May I pray any date prior to between 8 to 10, my lord.
The form-
10th of December. It's just here only.
And considering the depth aspect, my lord,
Ten lordship, on the 10th lordship, I have some other matter lordship, important matter. Lordship,
earlier occasion, considering the date of the trial court, it was fixed on today, my lord.
Achha.
That's lordship, other thing. He said, yeah, lordship, he is perhaps he's hoping for an interim order lordship. So whether it's possible or not, I don't know, lordship.
And I have not gone into the
Yes,
merits
lordship,
of the.
he has come for quashing of the affair and such an evening proceeding.
Let's
lordship.
just, Manojit, our matter to 10-12. For the admission column only. Okay, it would have the informant impleaded as phone number 2 has entered appearance to learned counsel. As what who's filed a objection. The same may be brought into the record. Full stop. So this also we can fix on 10 and take a chance. But 10 your date is there.
Lordship.
On that day, you tell the,
We have
which,
informed the.
Lordship, maybe on 9th, otherwise on 10th, lordship. On 10th, lordship, I have some many other matters, lordship. So we made it difficult for me, lordship.
oh, 9.
9.